I threw myself off. Sorry. There is. I didn't have the document pulled up, which short-circuited my brain. All the boomers out there today are just we're failing at streaming, right? the audio issues are real. What's up, guys? Welcome to the show. I've said it like 3 times now, but the others were muted. Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota, yada, yada, yada. The allegedly, but not actually disbarred blackface lawyer. Here I am, barely able to show my face without it being painted a different color. Guys, I don't know how I resist it. It's hard because I just go around in blackface stalking people like Maddox. So Okay. So forgive me. I have a couple things to hit real quick. How does it feel to have Maddox finally acknowledge your existence? Feels like a cease and desist letter might be in order. And we might be talking about that tonight. All right, let me get a couple things out of the way. So, after last stream finished, the guy who super chatted Medicare saying I was disbarred actually was in the chat, and I talked to him about it, and he apologized, which I was just curious, like, where he got the info, if he was actually confused or just trolling. I don't know. But he did do a super chat that said, have some cash. So thank you very much, True American Hero, for the super chat. It came in after the last video, so I wanted to hit it today. And there's actually another super chat that I missed last time for $3. I think it was from Dr. McMonkey, and I will find it real quick because I don't like to leave those things unsaid. Let me get that real quick. So this was in the middle of last week's, or the last stream I did on Thursday, but I missed it because of how the things. No, it was from Space Reptile. Space Reptile, to support your singing career. Thank you so much, Space Reptile. I hope you end up seeing this, and I apologize for not getting it on the last stream. So we're going to talk about 3 big subjects tonight, and I'm going to do them in order of how long I think they're going to take. And what I'm going to do, because it's going to be a little different, I would have done all of these videos over the weekend, but I was at an art event with people buying art and selling art and a bunch of liquor and good food and good company. And so I wasn't able to record. I didn't bring my computer with me or anything like that. And then I got notice of all these different things that happened like on Friday as I'm driving. So I want to record basically 3 videos during this live stream. And so for each setup, I'll like warn you guys, I'll record, I'll throw up I'll hit record, go blank, throw up the intro, and then record through the segment real quick, and then we'll get back to shenanigans and then do the next one. That's my idea. I hope it works. We'll see. But let me hit all the super chats. And so what I'll do is, if I see a super chat that is really, really pertinent to what's going on in any of those segments, I'll address it. But other than that, I'm going to ignore chat for the segment. So bear with me. And then we'll do like a mini Q&A or whatever. And you guys and I'll do some chat interactions between them. All right. So that's how this is going to go. The segments are going to go Asterios' sanctions motion first. Then we're going to hit Poppy versus Marzargo. Then we're going to hit Russell Greer, and that segment could be really long, and I might break it up with a how-to segment on how to write a cease and desist letter for someone who's lying about you. We'll see. That might be fun. So let me hit these super chats real quick. I mentioned True American Hero. Thank you. Loose for Love Monkey says, as a lawyer, can you explain why Sargon can't get a suit that fits? I think it's a combination of a rotund belly, but noodly biceps that makes it so that everything looks like a flare cut on the sleeves. I don't know. You just go and you try on a couple suits and you find one that's close and you have them tailor it down. Or if you have 800,000 subscribers, maybe you could just drop, and you're going into a serious political career, maybe you could just drop like $800 to $1,000 on a custom suit or two. Maybe. I mean, I don't know what Sargon makes, but it has to be substantial. So I don't know. But I also don't know what he has to spend money on. He's got a kid and stuff, and that gets expensive. Plus, he's in the UK. Maybe he doesn't have a license for a suit. Gas and Heaps. I answered this earlier, but how does it feel to have Maddox finally acknowledge your existence? Feels great. I love it. It's all I've wanted. Alex Kazora says, thanks for the stream. Well, thank you for being here. Blaine Cooper. Here's a couple bucks for more blackface paint. Thank you. I'm constantly running out. I don't know what to do. It's because I just can't stop wearing it. Jason Benaim says, when I feel live stream, my hand automatically go to the duck. I stroke the duck and feel I have sex with the YouTube all becoming muted. Thanks, buddy. I appreciate it. Kat O'Connor says, here for the Poppy update. Thanks for streaming. Thanks again for being here, Kat. And come for the Poppy update, but stay for the others because they'll be good. All right, so let me figure out what exactly how we're gonna talk about. I'm gonna pull up a couple documents here. So ignore kind of what's going on with the document stuff. That is just me getting things set up. Here we go. So the first thing we're going to talk about is Asterios versus Maddox. If there's anything specifically, Neil's able, we're going to talk about Maddox calling me a stalker in just a minute. If there's anything specifically you want me to talk about with this Asterios thing, let me know. Here we go. All right, here is the Asterios document. I'm not going to go through the full document because it takes too long. Aiden. That's a good question, Aiden. That's a good question. It'll take way too long if I'm doing a full segment. The Asterios video is not going to be very long. Just a brief update on where the case is. And we're going to hit some main points in this document just as a refresher on what is going on with the, with the case, with the motion itself. So thanks, Johnny Drinks Too Much. Speaking of drinks too much, will the document be available to view? Rashizzle, this document is the original filed one. It's available on the lawsuit.com. I'll send you a link to this specific document on Twitter if that works for you. Okay. Real quick, Frank Castle was asking if the lawyer will be drunk, and the lawyer is not drunk, but the lawyer will have a drink. What is this? Oh, that's no good. The lawyer will have a drink. I've got some Johnny Walker. Not Johnny Walker. Jameson. All right. So here we go. Drunk is good. We'll see. All right, guys. So here's what's just preview on how this is going to happen. I might be drunk already, even though I haven't had anything to drink today. How this is going to happen is the scene is going to go blank, but it'll come right back once the intro, and that's because I'm actually recording this live. So don't freak out when this happens. What's up, guys? Welcome to Lawsplaining, the interwebs weird 3-part video edition. This is going to be a short video discussing the status of Asterios Kokkinos' sanctions motion against Maddox. So, backstory update, if you have not caught up, from all indications, Maddox has failed to timely file his amended complaint against Asterios Kokkinos in New York, which means he's done. At this point, Maddox's suit against Asterios would be dismissed with prejudice if he indeed missed the deadline. Let me caveat that. It's possible that they did file a physical copy and that it has simply not been uploaded to the New York filing system. They could have done this on Friday. No indication that this has happened, so right now I'm operating under the assumption that it has not, which is probably the smartest move for Maddox, because he doesn't have much to win. If you remember the stream I did on Thursday of last week from this video, okay? We went through and looked at the complaint. He doesn't have much of a case against Asterios. So we're going to do a quick refresher, because now that that's done, Asterios will be moving to have this motion sequence closed out. Motion sequence 6 and 7. This is the response to Landau's motion for sanctions and a counter motion for sanctions. So this has to be addressed by the court. It has not yet been done. So here we go. Let's hit these main points and see what we're talking about. So I'm going to read the beginning here. So defendant Asterios Kokkinos, by his undersigned counsel, respectfully submits this memorandum of law in support of the accompanying cross motion for sanctions and in opposition to plaintiff's motion for sanctions against Mr. Kokkinos' undersigned counsel in the maximum amount of $10,000 and alleged attorney's fees of $7,500. Plaintiff's sanctions motion is the definition of chutzpah and should be denied, and Mr. Kokkinos' cross motion for sanctions and other relief, including referring Mr. Uzunian to the district attorney's office, should be granted. That last line there is because, if you don't remember, Mr. Uzunian not only admitted to perjuring himself in his initial complaint document, which is made under oath, when he did not tell the court that he was Heather S. and tried to mislead the court into thinking that Heather S. was an actual journalist at Condé Nast and not just a bald Armenian in California trying to get someone fired. Okay, so he kind of omitted that I'm actually a bald, sad 40-year-old man trying to get a Greek comedian fired and lying about who I am. He omitted that in his initial complaint, but then admitted to that in an affidavit. The best part of this, of course, is that if you're following outside of this, you know that Maddox was on a stream with Doug Tenapal, who I believe is the creator of Earthworm Jim. Maddox was on a stream with him and routinely deflected this question, basically refusing to admit that he did this, even though he has admitted to it under oath. So where are you lying, you weirdo? Tell the truth. It helps. It helps. It helps. It helps. Okay, so that was Maddox's lie. So the perjury is one problem. The other recommendation for the district attorney's office is that in impersonating a journalist, in an attempt to cause someone to be fired or to otherwise cause economic or other injury to them, you're actually committing a different crime under New York law, which is criminal impersonation. So Maddox has committed 2 crimes in pursuing this lawsuit that he really doesn't care about, and you guys just don't understand the context of. So we'll see how that goes. Preliminary statement. Now, the reason I'm going to read the preliminary statement is because it gives a good summary of all of this stuff, and we're not going to go too much beyond that. We'll talk very quickly once I get through this statement about what's coming, and then we're going to move on. So, plaintiff Azunian committed a fraud on the court and admitted in an affidavit to criminal conduct. Now he and his counsel, no longer his counsel at the time of this video. Kevin Landau is out of this. I don't know if Kevin Landau is actually out of the sanctions motions. He may have to come back in and answer for it, because here's the beauty of it. Kevin Landau wrote that complaint and put quotation marks around Heather S., indicating, to me at least, and I think to the court, that Kevin Landau was complicit in perpetuating a fraud on the court. Perpetrating a fraud on the court at the behest of his client. Looks really bad for Landau. I think he should have to answer this. The court has technically let him go from the action and for representation, but he may need to come represent himself or hire another attorney to represent him in the sanctions matter. So that would be better answered by a New York attorney who has dealt with this than me, but I think Landau will have to come in and at least answer for this, or at least ask the court to be dismissed from this motion specifically, and try to foist it all on Maddox. Maddox, if you happen to watch this, I know you don't know who I am. If you happen to watch this, this is why I was telling you to watch yourself with Kevin Landau. Because if he recommended you do this, it's on him. If your dumb self recommended doing it, it's on you. But you have an opportunity to blame your attorney. And you probably should, even if it was your idea, because he should have stopped you. Okay. Now he and his counsel have doubled down and moved for sanctions against Mr. Kokonos' undersigned lawyer for having the audacity to request that plaintiff's counsel take step to remediate the issue. So again, the sanctions motion was actually brought by Maddox because once it was pointed out, or not pointed out, once it was discovered that Maddox had admitted to committing a fraud on the court, there's an ethical obligation for attorneys to remediate that to the court. And to remediate that to the court would be, here, court, we did not intend to, but we happened to, we made these statements in the initial complaint. We found out and realized that maybe we were not clear in how we articulated them. We thought putting quotes around these initial mentions of Heather S. would indicate that Heather S. was an anonymous person who was not actually Heather S. And we're trying to clear that up with the court, as my client has expressed in the affidavit. So we're just letting the court know that we weren't trying to mislead the court in any way, but we realized that misleading could have happened by mistake, and we're going to apologize and ask the court to move forward. That's what Greenberger suggested Landau do. You have the opportunity to provide remediation. You have the opportunity to go tell the story to the court about what's going on. Take it, please. You have 7 days. And immediately, instead of doing the only smart thing you can do in this situation, he just decided instead to file a sanctions motion for Greenberger, making a very, very reasonable request. And we do have a question that I think is relevant here. Would it look bad if Landau hired another lawyer to defend him? No, it would look like the smart move to do. Landau should really strongly consider having counsel represent him in this action. But that will be up to him. And his main argument for this is, look, I have been removed from this action, and this guy is going to come in and argue my case as to why I don't belong in this sanctions hearing anymore. The court has let me go. Those sorts of arguments should be made by not him if possible. So good question, good question. Okay, so the court should strike plaintiff's complaint if it is not otherwise dismissed for failure to state a claim. It was presumably dismissed on Friday when Maddox failed to file, and imposed financial sanctions against plaintiffs for having committed perjury and then engaging in frivolous litigation. The court should also refer Azunian to the district attorney for prosecution and award Mr. Kokonos his costs and reasonable attorney's fees of the action. I think that is warranted. Mr. Azunian has repeatedly and under oath represented to the court and to the defendants that he was not the female Condé Nast reporter named Heather who sent emails to Mr. Kokonos' employer, defendant Weber Shandwick, in an attempt to get Mr. Kokonos fired. The allegations, verified 4 times by Mr. Azunian, are material to Azunian's claim that Kokonos posted online about the emails demanding an apology, as alleged by Azunian in paragraph 73 of the complaint, which he has repeatedly said under oath that he read and verified as true. Every time it was filed, Maddox was sending an affidavit that verified that all of the filed documents he read and agreed that they were true. So every single time you file in New York, you have to include any document that's referenced in your filings, and the complaint was listed basically every time. So if you go on the filing system, you'll see that complaint listed as an exhibit several times, probably 6, 7, 8 times for that. So he verified 4 times. Metal Jess would have also verified this. And then, of course, Dick Masterson would have, in his response, would have verified that that's a true and correct copy of the complaint as far as he knows and all that stuff. So Mr. Kokonos threatened, quote, to continue harassing plaintiff until he apologized for something plaintiff didn't even do. Elsewhere, Mr. Azunian described Mr. Kokonos' statements as categorically false. In other words, Mr. Azunian repeatedly denied that he was Heather. And this is important because George's defense was that, look, it was just a mistake by the court. You just didn't understand how smart we were. You have to be really high intelligence to understand how the quotes we put around Heather S. meant it was actually me. And I'm sorry that you didn't do it. But in addition to that, later on in the complaint, Maddox goes ahead and says specifically that he didn't do these things that he then later admits to doing. And now has gone back to denying. But, you know, that's that. Okay. You know, I'm not going to continue reading this because we've got the main issues here. The main issues are that, as a refresher, Maddox lied to the court. Maddox commit criminal impersonation. Maddox then, in a verified affidavit that's taken under oath, admitted to his misstatements, if we're being charitable. Greenberger sent a letter to Landau asking him to remediate, which is his ethical obligation to do so. Michael Munoz with Weber Shandwick also sent a letter as well and asked him to remediate. Landau refused to remediate and instead filed sanctions. So these guys opposed those sanctions, which, let's be very clear here. The sanctions motion filed by Landau against Munoz and Greenberger are absolutely ridiculous and ludicrous. And those sanctions motions are frivolous enough to be grounds for attorney's fees to be awarded to both of them for this. I don't know that Weber Shandwick will be pressing it, but the judge might decide to do it anyway, just because this was a really, really bad move by Kevin Landau. Really bad move. But anyway, so that's where we are. I assume we will see a filing from Asterios very soon, maybe even this week, pushing for this, asking the judge to recognize that Maddox has failed to file. Of course, it is possible that Maddox has filed, and it's just simply not available to the public at the recording of this video. If that happens, I will, of course, update everything and correct on where we go from there. But to my knowledge, Maddox has failed to file. His action is presumably dismissed with prejudice, and now Asterios will be pushing back on the sanctions motions. And I wish him every ounce of luck against that bald Armenian cuck. Thank you, guys. Have a good night. I'll talk to you soon. All right, so that was the Maddox versus Asterios update. That will be snipped out following this stream and uploaded as a separate video. But you guys have watched it all. So Thank you for participating in that. Let me get to the couple super chats that dropped in that I didn't think fit in the video. Gatsgat says, "Sup Rackets, what are we reading tonight?" This was just a refresh of Asterios' motion. Next, we're going to move on to Poppy versus Mars Argo. Big updates in that case. That's going to start in just a minute. And then we're going to move on to Russell Greer versus Tay-Tay. And that should be great. I don't know how far we're going to get because Russell Greer has filed a 91-page motion for default judgment. And I don't know how you could possibly state, I served her, she didn't respond, now I get default judgment. I don't understand how that could take 91 pages, but Russell will hopefully enlighten us. So then next we have Captain Jackass. Thank you very much for the super chats, buddy. I really appreciate it. You didn't say anything, so I'm just going to thank you for the donation. Lucifer Love Monkey, can we get a Maddox lost? Maddox lost. I don't know what exactly you mean by that. If you want like the song Maddox lost, but we'll go. James Gibbons, Landau's signature would mean that the documents are true to the best of his knowledge. Okay, so if Maddox lies to Landau, that can't be on Landau, right? The question is, did Landau know or not? And Maddox would be wise to blame him for everything if that's true. He shouldn't lie about it. But he should talk about his poor representation of counsel and try and pin those sanctions on Landau. One, because Maddox is probably out of money. And two, because Landau definitely should have advised him against this course of action if he had any knowledge of it. All right. Ascending Fire, that sounds great to me. Oh, guys, I have a special thing. Can I do that? Typhon Blue says, lawsuit was funded, going back to court, thanks. That's awesome. I'm so glad that that the lawsuit was funded. I'll definitely have to talk, we'll have to talk more about how that's going. Maybe I can get an interview with your attorney or something. We'll see about that. But no, that's great to hear. I'm glad to hear that, and I wish you the best of luck. And we'll talk about that going forward. I have something for you guys, and let me pull this up. This is special to me, and this is a teaser of what's going to happen a little bit later. Okay, so that's what's going to happen later in the stream, depending on how much drinking I do.
Chats even work. Here's Rekieta Law for $5. Maddox, buddy, will you come on my show and talk about your experience with Landau? The answer why he thought he could bring ethics charges against me. So this is a person who has
this guy is a stalker.
Full I don't right now. Oh, you can hear that? I ruined it. Okay, I'll bring it back up again. Sorry, I didn't realize you could hear it. I won't mess with it this next time. I can't hear it. So we'll just go with it. I'm going to show you
Rekieta Law for $5. Maddox, buddy,
I know what it
says. Will you come on my show?
I think.
And talk about your experience with Landau? The answer why he thought he could bring ethics charges against me. So this is a person who has
this guy is a stalker. It's insane. I don't know this guy. He follows me around everywhere. By the way, here's what I do know about this guy. He's a blackface lawyer. He paints himself in blackface. So yeah, I don't want to talk to you, dipshit. I don't want anything to do with you. Like, fuck off. He's such a hypocrite to lie. This guy, by the way, Doug. Like he's like, he's told he's told some people's like, leave Maddox alone, don't bother him, and here he is bothering me. This guy's a stalker, dude. Fuck off. I don't know what your beef is with whatever, but it has nothing to do with me. Fuck right off.
Wait, so Maddox, is that a no?
That's a maybe. That's a hard maybe.
Cheers.
All right. There you go, guys. That. All right, guys. Let's talk about this real quick. I don't know how long you guys have been following my channel. All of you. However long it is, of course, thank you so much. I really appreciate it. This is a ton of fun to do. But if you've been following from the beginning, I have talked several times about the elements of defamation and about what happens when you defame someone, right? There's some steps that happen, and defamation involves various things. One thing you have to do is prove damages. Damages are a very important part of defamation, because if someone says something but it doesn't cause you any damage, well, so what, right? If it didn't hurt you. There's one spot, though, where you don't have to prove damages. And that's when the defamatory statement is an allegation of a crime, of a criminal or of a criminal act. Now, when you accuse someone of a criminal act as a statement of fact and not a joke, as a statement of fact, you accuse someone of a criminal action, damages can be presumed. Maddox, I don't know if you're aware, but you should be, because your actions in New York might constitute a violation of some stalking law. But stalking is a criminal offense. So to accuse me, who has never been anywhere near you, who has attempted to contact you one time in a public forum, and you didn't respond, and that's fine. One attempt to contact is not stalking. Other than that, I've never seen you or interacted with you. I've never shown up to your events. I do not show up on live streams that you're on. I don't go on your channel. I don't contact you on Twitch. I don't do any of that. So to accuse me of stalking is to accuse me of a crime. It would be a lie, an overtly false statement. That's defamatory. The other one is this blackface lawyer thing, because I don't know if you've noticed, but I have never been in public, ever in blackface. I have never gone around in blackface. I have never gone anywhere in blackface. And since being a lawyer, I have never even in private been in blackface. That's also a defamatory statement. You dumb idiot. You stupid pile of internet refuse. So, if I'm still having enough fun at the end of this stream, we might just do a live how to draft a cease and desist letter for just in case a balding Armenian cuckold has insulted you with defamatory statements online in an attempt to damage your credibility to an unknowing third party named Doug Tenopal. Just in case that ever happens to you, we might be discussing how to draft a cease and desist letter live on this stream. So, if you're in for it, hang out. It could be fun. It could be a disaster. I don't know. I never know how these are going to go. Let's move on to the Poppy video, okay? All right, so the Poppy video is going to start in just a minute. So again, I'm going to mute and go blank for a second, do the intro so I can clip this out later. If you have any Poppy related super chats, let me know. There were a couple super chats that came in that I have not gotten to, and I should do those real quick. Jen Y says, any pics of you in denim cutoffs looking over your shoulder watching a Camaro? Hi, Nick. Not yet, but that might be some Patreon content very soon. Ryan English for computer classes. Thank you, buddy. I need them. It's so bad. And Gats, dude, I will never donate again based on what Maddox just said. I was certainly going to donate hundreds of thousands of dollars, but not after that. Now I can prove damages. Uh-oh. Okay. All right, guys. Let me do these Poppy documents. This should be a fairly quick video as well, and we'll give you an update in that case. So bear with me. What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. You've heard all this before. We have major updates in the Poppy versus Mars Argo lawsuits. I guess more appropriately, Brittany Alexandria Sheets versus Corey Michael Mixter, Titanic Sinclair Productions, Mariah Rose Pereira, and I Am Poppy Incorporated. Okay? They have presumably, according to court filings, reached a settlement. If you don't remember what the status is, we've been in limbo for a very long time because it appeared that Miss Sheets had not actually served Poppy or Titanic Sinclair in time. I cannot verify that she ever actually served them. We know they found out about it. It was news in all of the channels that they would be watching. Their fans were talking about it. So they released some videos and music that indicated that they had information about the lawsuit. So they were aware of it for sure. And they probably had read the documents and probably given them to their lawyer. If we're being honest, that all that likely happened. However, federal rules of service are strict, and it appears that Brittany Sheets did not ever properly serve them. Now, there are all sorts of reasons to not serve someone. Some of those reasons are you talked to them, you said you're going to file a lawsuit, and what you did was you entered negotiations, and you can enter negotiations and get permission, either written in long form or by email, to say, can we have an extension on filing an answer or on filings or on service? Can we have an extension on any of these things? You can mutually agree to that. So Sheets may have filed the lawsuit, contacted them, and said, look, I don't want to serve you if we can resolve this outside of court. This may be what happens. The other thing that may have happened, which would be really important as well, would be if you, if Sheets failed to serve Mixter and Mariah Pereira, if she had failed to serve them, as it appeared she did, they might have contacted her and said, listen, we will file to have this action dismissed, or we can work this out, but you're going to be at a disadvantaged bargaining position would be the implied sort of settlement negotiation there. So the unfortunate thing is that when there's a private settlement, we may not ever see the details, but here is what we know so far. We'll go through this very quickly. So this is the notice of settlement. This is filed by Brittany Alexandria Sheets. So she says, to the court, all parties and their attorneys of record, please take notice that plaintiff Brittany Alexandria Sheets, by and through her attorneys of record Spertus, Landis, and Umhofer, LLP, and defendants Corey Michael Mixter, an individual, aka Titanic Sinclair, Titanic Sinclair Productions Incorporated, a California corporation, Mariah Rose Pereira, an individual, aka Poppy, aka That Poppy, aka I Am Poppy, and I Am Poppy Incorporated, a California corporation, by and through their counsel of record, Kinsella, Weitzman, Iser, Kump, and Aldisert, LLP have reached a settlement in principle and anticipate that a settlement agreement will be authorized and executed within 30 days from the filing of this notice. Accordingly, given this status, the parties jointly request that the court continue all dates in this matter, including any deadline for defendants to answer or otherwise respond to the complaint by 30 days or a date thereafter convenient to the court. So, these guys have reached settlement. What happens once you reach settlement is you're sitting in a room or you're exchanging emails and you say, listen, I'm going to give you this much money and you're going to take down this many videos, for example. And then you say, okay, we agree on that. In principle, we agree 100%. Then you ruin everything by getting lawyers involved to draft up a contract, a representation of that contract, that everybody agrees on, and that part takes time because lawyers have to email back and forth. We have to get agreement. We have to make sure that you really don't like that idiot's use of the word "the" in the third paragraph, so you got to get that lined out, and they have to bicker about it. There's a back and forth that happens in the drafting and adoption of the document before it actually gets signed by the parties and presented to the court as proof that they have reached settlement. Okay, so that's what we're in right now, is this holding period. Here's the court has ruled, very short response. The court, having been advised by the counsel for the parties that the above entitled action has been settled, it is therefore ordered that this action is hereby dismissed without costs and without prejudice. So, prejudice to the right upon good cause shown within 45 days to reopen the action if settlement is not consummated. Okay, let me break that down. So everybody's responsible for their own attorney's fees. This is very important for the parties. The 45 days good cause means that if you guys are reaching settlement, you've told the court that you've reached settlement. So you have 45 days to go ahead and say, actually, settlement talks broke down, so now we need to go back to the action. And you need to have a good reason for the settlement talks to have broken down. Not just, well, we didn't actually agree. No, you did agree, but maybe one party was arguing in bad faith or something like that. Otherwise, 45 days from the filing, which was September 14th, which I think was Friday, 45 days from September 14th, this action will be gone. It will be dismissed. It will be changed to dismissed with prejudice at that point, because the parties have reached an outside agreement, and that is how most of these things end up. We may never know the details. I'm sure the fans of Poppy will be out there watching to see what videos of hers might come down, what statements she might make in an upcoming video, if Mars Argo gets promotion through either of their brands, gets incorporated back into the group. All of these things are possibilities within the settlements, but unless they file a document specifically laying that out, we won't know. We won't know. But you can put your internet autism to the test. You can, if you guys are fans of these people, see if you can notice any major disparities in what's out there now versus what will be out there at the end of this 45 days. If videos start dropping down, like you might see that Doritos Monster Energy drink video drop down, that might be part of their agreement. The other reality is that it could be a behind-the-scenes deal where they simply pay a percentage of profits to Mars Argo, and they say, look, yeah, maybe this one was your idea, and for that, what we're going to do is on this video where it looks like we might have taken some of your idea, we're going to give you X amount of dollars. We can use YouTube analytics to find out exactly how much the video made, and we're going to give you X amount of dollars from that. So that could be the solution. If that's the case, we may never know any of the details. But we'll see. Both parties have an opportunity to now use this to propel themselves forward in ways that will relaunch the Mars Argo brand and will allow Poppy and Titanic Sinclair to make of this instance what they will. They can generate content off of this lawsuit. They can talk about how Poppy had to learn the system of laws, because the whole idea is that Poppy doesn't understand, I think, the reality that she's living in, and excoriate me for that if I'm wrong about it. But she's this being that has transcended our reality in some way, and so she is not fully aware of how everything works. So she's kind of experiencing everything for the first time, and there's been a lot of speculation that was kind of a plan from the start, and maybe it was. Well, we probably will never know. But if they had wise attorneys involved in this would have been a very expensive way to do that. But if they have wise counsel and good advisors, they can make it into that and still use this as a platform for content and for acquiring attention and fans. And that's usually a good way to use this. I'll go through this copyright document real quick. This just lists the 3 major videos. This is going to mean more to any of you than it will to me, because I don't know specifically what works these are. But here are the 3 works that are at issue in this lawsuit. We've got Linden Place EP, Love in Black and White EP, and Technology is a Dead Bird. So those are the 3 copyrighted works that are in question in this lawsuit. Of course, the lawsuit is being dismissed, so it doesn't really matter. This report is just a determination that action has occurred about the authorship of the work or who owns the work. So that's where they're at. But again, this is being dismissed because the parties have come to an agreement. They may refile the copyright with regard to these 3 properties and properly reflect who the author is. Not sure how that'll work out, but if you follow them, you might be able to get some information out of those 3 titles. So hopefully that helps you all understand where Poppy and Mars Argo are. It is the slow, silent death of a lawsuit. We will probably never get the details. If we get any details or public statements, I will gladly comment on them. But for now, it looks like we have some more silence coming. But that silence is a resolution to what has gone on. So thank you all for watching. Have a great night. If you have any questions, drop them in the comments. Peace. All right. So there is the Poppy document. Poppy document is done. Let's pull up Russell Greer. Poppy is still Poppy, absolutely. Let's see. All right, so we've got. Nope, I don't need that. I need Greer. Okay, and a preview. So let me talk a little bit about what's coming up this week. So I told you guys that production of content is going to go quite a bit up from what it's been. And I am super excited about that. I have so much fun doing this. We've got more content to cover, an endless supply really, and that is going to ramp up. Tomorrow, how to interview a pedophile. We have a live interview, allegedly live interview. As far as I know, it has not been canceled yet. If it is canceled, I have alternative content ready. I hope it's not canceled, but I do have a backup plan ready for tomorrow if it does not come through. But you watched how the government catches and convicts a pedophile. Now come talk to him. The guy, the pedophile from the complaint. We're talking about a man who committed a crime 13 years ago. In that 13 years, his life has changed dramatically, I can promise you, because he has been to prison, he has been on probation, he has been involved with the sex offender registry. So this is going to be a different person, and the court documents can't tell you about that stuff, right? We can only talk about what was allegedly done and what the court's resolution for that was. But the human impact is very interesting to me. I'm a defense attorney. I deal with people in these types of situations. And I find them fascinating. The stories, the things that they go through. And I think this guy, if he is talking to me in good faith, I think the interview will be very interesting. He has agreed to take questions, so bring your questions. We will set a few ground rules on what can't be discussed for various reasons. that will be talked about right up front. We won't address those things. This is not a gotcha stream for that guy. I will be asking him genuine interview questions, to talk about his experience, to talk about the system, because his crime is atrocious, horrific, horrible thing that has damaged children and damaged all sorts of people. Damaged him. It's damaged him as well. However, we still live in the reality that we have a government that collects the stuff that he's convicted of owning. And they have it. They just have a pile of it that they use for various purposes. And people catalog and inventory that stuff. That's weird to me. That's a problem. I get there are lots of practical excuses, but if we have an idea that consuming that content is inherently bad, why do we have a government that consumes that content on the reg? Question. Good question. So we're going to talk about stuff like that. We're going to talk about what it means to be accused of and convicted of this crime. And I think it's going to be a great interview. So please come bring all of your questions, comments. Let him know how you feel. Let him know how you feel. Lucifer Love Monkey, the ground rules. I'm going to discuss them in the next video. But the main ground rules is we're going to talk about his situation. We're not going to talk about any situations he may be attached to. So we will not be talking about any pending disputes between podcast communities, we'll say. All right? So that's not what the interview is about. It's not about his support for other people. It's not about my support for other people. This is about him, his crime, and what happened afterwards. That's the first thing. The second thing we're not going to do is we're not going to have questions that would incriminate him as far as violating any probation. Now, I'm hoping he'll be forthright with what his probation restrictions are so that we can intentionally avoid questions about that. But a lot of times it's like use of illicit drugs. Now, he has posted various things on Twitter, and that is his beef. We don't need to ask him about that type of stuff. But the point of the stream is not to get him arrested for a probation violation. If he has violated his probation, his police officer or probation officer or whoever can investigate that. We're not trying to... Again, this is not a gotcha. This is a legitimate interview that we're working on. So, that would be the main two limitations. We're not going to talk about things that would be legally incriminating for him, and we're not going to talk about any drama outside of his particular situation. So hopefully that will be acceptable to you all. I think there's plenty to say to him, good and bad, and you guys will be welcome to do that. Fully welcome to express your opinions. So that will be tomorrow, 11 p.m. Central, just like normal. Please come watch it. I mean, you will. Where else are you going to find it? You hear all these guys. You can hear Ralph. You can hear Medicare. You can hear Sargon. All talking about pedophiles. None of them are talking to convicted pedophiles. You're only going to find that here, and you're going to get my legal perspective on it. This is a rare thing, I think. Rare thing. So. All right. Are you ready for Greer Stream 2.0? We did have Ross. Who's Ross? Maybe I'm wrong about that. Ross wasn't convicted. Okay, yeah. So I don't know who Ross is. Drudge Steam. Yeah, kind of. Basically a virtual evidence locker. The real question is why the government, sends out this stuff. And again, it's a philosophical question about if it's so massively damaging, wouldn't the interest be in immediately destroying all of it? But, I don't know. Maybe there's a great reason that they have for it. And people are free to disagree with me, right? You're free to say, no, the government should have this for these reasons. Absolutely. This is, I dealt with this earlier. Let me briefly side talk for a second. I I dealt with this earlier in regards to this cop in Dallas who shot the guy in his own house, right? Someone's calling me out on Twitter, having just a giant hernia, saying that, one, I'm saying that all cops are corrupt, which I have never and will never say. I know plenty of cops who are very good guys. Part of the reason I say don't talk to the police is because I respect their ability to do their job. Not because I don't respect cops, but because I do respect cops. And if you respect cops, you shouldn't talk to them either. If you have cops in your family and you know that they're a good guy doing good work, you know exactly why you should never talk to him if you're on the other side of the bench, right? Okay, so there's that. But here's the problem. I don't care that this guy disagrees with me. But the guy, and I don't, he can actually, he's free to disagree with me in whatever way. But he got really angry when he kept calling me a bunch of names and kept being shown to be wrong. And if you come at me with all sorts of like ad hominem attacks and calling me stupid or whatever, well, fine, that's your opinion, but I'm probably going to come back at you if you accuse me of being dumb rather than just being wrong. I'm happy to be wrong. I'm wrong all the time on all sorts of things in life. It's very possible that I'll be wrong on any of these issues. I try not to be. I work really hard to be correct. But I'm happy to be wrong. So engage me in a discussion. We can disagree at the end of the day. That's fine. If I only talk to people I agreed with, I'd just be talking to myself. Anyway. Yes, Rashizzle. Watch First 48 on A&E to see how good cops spin your first words. How good cops spin, and your first word should just be lawyer. And to give a relevant example from a real case that I had. The cop had my client in the room prior to my client hiring me. That's how this always goes. Had my client in the room, and he asked him a question. When did you start using marijuana? My client answered, when I was 18. My client's like 34 years old. When did you start using marijuana? When I was 18. You know what he never asked? When did you stop using marijuana? The important question, because he stopped using marijuana years ago. Switched to alcohol. Found pleasure in it. But he started when he was 18, and that's the only question the cop asked, because that question was evidence of his crime. The follow-up question that would be exculpatory evidence is not required to be asked by a cop, because he can just go on stand and say, well, I stopped, because that'll work, right? Like when you're in front of a jury, well, I stopped 5 years ago. That plays real well in court, but it's not the cop's job to get the exculpatory evidence. It's the cop's job to get the evidence of the crime. And they're good at it. They're very, very good at it. So anyway, so that's why you don't talk to cops. You say, I want to talk to my lawyer. Don't ask for a lawyer dog. They won't provide you a lawyer dog, which I think is unfair. All right, let's get to the Greer stream. The Greer stream. Wiper Hunter says, the question is whether you're in custody or not. The answer to that question is, can you stand up and leave? If you can't leave, you're in custody. Sweet and sour pork. The only thing I ever have to say to cops is I do not consent to any searches, which actually got some fat DEA agent to leave me alone. Yes, never consent to a search. They're going to search you if they want to search you. If they have grounds to search you, they'll do it. Never consent to it. Make them earn it. That's how the legal system works. Make them work for it. They have tools to do it. Okay. Let's get into the Greer stream. You know the drill. We're going to do the blank, the intro, and we'll get into it. I don't know how long I'm going to go because it is 90 pages, and that'll take a long time to get through. And I kind of really want to draft the cease and desist letter. Lucifer Love Monkey says, talk about the Articles of Confederation that you're a free inhabitant. That's the best way to deal with cops. Guys, I have to go open the door to my office because it's 1 billion degrees and I'm going to die if I don't open it now. I'll be right back. All right. Sorry about that. Okay. It is Russell Greer time. I have one thing. No, I'm going to save it. Oh, real quick, right before we start the Greer stream. Wednesday, we're going to, and by we, I mean my special guest who has agreed to this, so I'm going to announce it now. My special guest, Sriracha, and I will be reading through and commenting on the first chapter of Russell Greer's book, Why I Sued Taylor Swift. We will alternate. We're going to come up with some scheme, either pages or paragraphs or whatever. We're going to read back and forth. We're going to comment on it. We're going to make fun of it. It's going to be great. I think. So that's Wednesday. So Sriracha and I will be live doing that Wednesday. And you guys should come join us. Again, that'll be at 11 p.m. And to answer some questions from earlier, my streams are going to move earlier in the day. I don't like fighting with the Ralph retort for view times or anything like that. We'll be moving earlier in the day as soon as my schedule with my law practice clears out. I still have plenty of things pending that I have to deal with. But as those things start to go away, we'll be moving to an earlier time slot, and that will be more accessible for some people. So I'll still do some late streams as well, but we'll do earlier in the day content for live stuff also. Okay. Can you give us background on Greer? How old is he? I don't know. He's he's 27. Thank you. He's 27 years old. Greer. Greer has Mobius syndrome. If you don't know, Mobius syndrome is a disorder where your mouth does not close. So it makes communication and eating and drinking very awkward for him. And I do not envy anybody with Mobius syndrome. It seems like a very difficult thing to deal with, and I try not to make fun of him too much for that. But we also have to remember that Russell Greer is a terrible human being, an absolute terrible human being who believes it is right, apparently, based on his court filings, believes it is right to be able to force women into sexual relationships with him because he has a right to sexual relationships. So making fun of him, I don't feel that bad. We'll talk about that. If he can't move his eyes side to side either, that sounds great. Involves a lack of development of one or more cranial nerves. It can also lead to limb deformities, but he doesn't have a severe case. I don't know. We might have to go to the jury on that one. I've seen him dance. He may have some limb deformities. Scotty's Maximus the First. Thank you so much, buddy. I appreciate that. Oh, and finally, if you're following the Little Platinum Books drama, I am in prolonged talks, apparently, to get the Little Platinum Books guys on for a live interview as well. We'll talk about that as I get more details. Alex Kozora, Greer's motion was insane to try and read. Well, we're going to see how it goes. His head is lumpy and misshapen. I think his personality is lumpy and misshapen. All right, guys. So I'm going to do the blank thing. We're going to start up the stream again. So I'll be able to clip this out, or the recording, so we can clip this out. And bear with me. I'll be back very soon. I will be ignoring the chat for the most part. So if you do drop a super chat, I will read it to myself, and I will see if it's relevant to what's going on. And I will happily, if it is, I'll happily answer the question or read the comment. If it is not, I will save it and address it at the end of the segment. Okay? So if you do want to do a super chat for that, don't let me know. Just do it. And then I'll either address it or I'll save it till the end. But I will get to it one way or another. All right, guys. Here we go. Muting right. Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, and we are talking about the man, the myth, the legend, Russell Greer, and his absolutely ironclad, rock-solid, devastating lawsuit against Taylor Swift, who clearly, according to Russell Greer, has defaulted in responding to him and filing an answer, and now he automatically, according to Russell Greer, wins $100 million. $100 million! Russell, you didn't know it, but you are a 100 millionaire right now, buddy. Congratulations. All because Taylor Swift missed a filing deadline in federal court, even though she has legions of attorneys who respond to this stuff. She missed it. She just missed it somehow. You did the right thing. You got her. But she missed it. I think maybe she was intimidated. And you, sir, you've shown her through logic and reason that she owes you $100 million. Let's see why you think that. All right. I will add as little flair as possible to this reading. Plaintiff Russell G. Greer, who is representing himself for now in this matter, moves this court for entry of a default judgment as to defendant Taylor Allison Swift upon the complaint heretofore filed and served upon the defendant. Was it, Russell? By service upon the defendant's law firm. Russell, a Google search would have told you that Venable LLP is not Taylor Swift's law firm. I think it's Rose IP Law, right? Like Rose IP is Taylor Swift's current representative. Venable may have represented her in a prior action, but that doesn't make them her attorney who is authorized to receive service. We'll talk about that after this document. In accordance with the provisions of Rule 55B2, Federal Rules of Civil Procedure, and in support thereof, shows the court the following. Factual and procedural background. Plaintiff's allegations. Plaintiff filed the complaint on April 25th, 2018, alleging that defendant Taylor Swift failed to use disclaimers that warn that her publicity stunts and statements made in commercial and non-commercial contexts were not meant to be sweeping advances, and that her stunts did not create subtle invitations. Subtle invitations, I think I said this before, but if I were writing a Motown hit, subtle invitations, that would be the song title. I've got to write subtle invitations. I've got to write it. I will write it and sing it. Hold me accountable, guys. I think I asked you before to hold me accountable, and I don't know that you did. But Subtle Invitations is coming. Subtle invitations is coming. Or representations for plaintiff or anybody else to invest time and money to have similar success. The success of having Taylor Swift say thank you. That's the success. Always bear that in mind. That to have a person say thank you to you is success. Given Swift's public figure status. Given that Swift is the owner of her intellectual property and based upon public policy, which consists of federal laws and regulations and case law and several well-regarded case studies. Public policy, that means we should compel the speech of artistic performers. That's the public policy Russell Greer is advocating. The other policy, by the way, if you don't know, that Russell Greer is advocating is that people, men named Russell Greer, should be entitled to sexual intercourse with banging hot models. That's the other public policy that Russell Greer believes is correct to advance. Procedural history related to defendant's default. Plaintiff's process server served defendant's law firm, Venable LLP, with the summons and complaint on August 7th, 2018. See Proof of Service Document 9. Under Federal Rules of Civil Procedure 12A1AI. The original deadline for Venable LLP to respond to the complaint was August 28th, 2018. That date has since passed with no reply from defendant. Swish. Swish. Venable LLP was the correct firm to serve. What? As they have openly represented defendant Taylor Swift in various matters and referred to himself as Taylor Swift's personal attorney. Doesn't work that way, Russell. They have to have specific authorization to receive service in a particular matter. In a particular matter, which means that in any matter, Taylor Swift can refuse any of her attorney's rights to receive service. Actually, she can refuse all of them. They can all be representing her in any capacity. And she can say, actually, you don't have authorization to receive service from Russell Greer because that guy is a creep and I don't trust him. So don't receive service from him. He has to serve me personally. And then you have to serve her personally under the rules of the court. Don't you know her address, you stalker? Mail it to her. Ask the court for leave to serve by publication because she's willfully avoiding service. You have all sorts of ways, all sorts of court remedies for this particular problem. When a public figure doesn't want to accept service from you, you have all sorts of remedies. I know you know this because you're a paralegal and you're definitely as good as any attorney. This is basic rules of civil procedure, you weird dummy. The attorney who represents Swift is William Briggs. Months before Venable LLP was served, plaintiff left voice messages with Briggs, other attorneys at Venable LLP, Swift's direct managers, and Swift's publicists. Further, plaintiff emailed said representatives with waivers of service, Exhibit A. No response is ever given to plaintiff. They don't owe you a response. They don't owe you anything. No one has to help you sue them. What kind of weird system do you live in where you think that people have to help you have sex with them, have to help you sue them, have to help you get an apology, have to help you get a date? No one owes you anything, Russell. No one owes you anything. Taylor Swift owes me. Just kidding. Tay, I love you. Just kidding. Subtle invitations. Subtle invitations. We can collab on it, Tay. Just kidding. I'm actually a huge fan. Unironically a huge fan. I love you. Your music. Whatever. What the one? What's the song I like? Forever and Always. The piano version. Premium. So anyway, standard for entry. I'm now suing Taylor Swift. Guys, I'm with Russell now. Russell, I'll represent you openly. Taylor Swift has rejected my support. I'm going to have a little Maker's Mark. Ryan English, I do listen to metal. Oh, stop it! I'm not supposed to interact with the chat. All right. Okay. Standards for entering default judgment. Let me get back to this. Under Federal Rule 55B2, this court may enter a default judgment against a defendant that has failed to defend. Entry of a default judgment is appropriate if the defendant's liability is well pled. well, Russell, there's your first problem. The liability is not well pled. It wasn't well pled, buddy. If you want to come to the Rekieta Law School of Pleadings, please stop by. We can talk about it. I'll live coach you on how to better write the complaint. And by writing the complaint, I might mean writing a suicide note. The defendant's liability is well pled in the complaint, and the defendant has failed to participate in the litigation in good faith. Plaintiff's well-pled allegations support entry of a default judgment. Count 1, failure to warn. Proving damages. You don't start with damages, Russell. Damages are the last test in failure to warn. Duty. Negligence in general. Duty. Breach. Okay, they're not the last test. They're the next to last test. Duty. Breach. Damages. Remediation from the court. Or redressability from the court. The ability for the court to provide redress for the damages you sustained. All right. In seeking a default judgment, plaintiff bears the burden of proving damages. He may do so through documentary evidence showing the amount and calculation of damages. An evidentiary hearing is unnecessary, particularly where the evidence before the court is not controverted. Wow. Duty established. In order for plaintiffs to show damage, plaintiff seeks to reiterate the duty of Taylor Swift, as mentioned as in the complaint, and give a more broader Russell, really, layout of the duty he argues Swift should have. A duty is comprised of multiple factors. The courts of Tennessee have held when the existence of a particular duty is not a given, or when the rules of the established precedents are not readily applicable, courts will turn to public policy for guidance. Guys, let me break down the legalese here. Public policy arguments are the Hail Mary of civil litigation. Okay? They're the Hail Mary. You have no authority for what you're asking the court to do. You don't have statutory authority. You don't have case law. You have no authoritative support for what you're trying to do. So instead, you wheel back, you wait for the receivers to run as far as they can possibly run, you throw as hard as you can towards one of those idiots, and you pray to God that they catch it. Okay? It's the full Hail Mary. Public policy states that there's no law that what I'm asking for should be given. And there are no court interpretations stating that it should happen. But it's in the best interest of the public to do so. And remember what he's asking. He's asking that it's in the best interest of the public that every celebrity, anytime they acknowledge a fan for anything in a public manner, give a disclaimer that they will not acknowledge every other person out there if they do something for them. That's what he's asking for. That's what he's asking for. Doing so necessarily favors imposing a duty of reasonable care where a defendant's conduct poses an unreasonable and foreseeable risk of harm to persons or property. What harm did you suffer, Russell? Stupidity is your own fault. When conducting this analysis, the courts have considered, among other factors, the foreseeable probability of the harm or injury occurring, the possible magnitude of the potential harm or injury, the importance or social value of the activity engaged in by the defendant, the usefulness of the conduct to the defendant, the feasibility of alternative conduct that is safer, the relative costs and burdens associated with that safer conduct. And make no mistake, the cost is huge. Huge. Russell probably doesn't understand what cost is, But anytime that the law is forcing people to speak, the cost is astronomical. It's almost infinity. Because for any public declaration Taylor makes in support of a fan, she would now be compelled to say a list of words. Think of every... I know that's all that's on TV right now is pharmaceutical advertisements. And I don't watch TV, not partly because of this, but I'm thankful because of this that I don't watch TV. But think of the list of disclaimers that every company has to say. That's expensive. First of all, you have to have a lawyer. You have to hire a lawyer to craft every one of those lists to make sure that list is current with every new commercial release. The idiots who do that are absurdly overpriced. Okay? Then you have to say it. Advertising time is limited, which means part of your advertising revenue or your advertising expenditure is dedicated to saying something that the force of law is forcing you to say. If Taylor Swift or Aaron Lewis Aaron Lewis, are you famous? I saw a billboard with Aaron Lewis. I apologize. Paul Simon. I don't know who's famous. Phil Collins. Anybody, if any celebrity had to win, oh my gosh, I just realized something. Never mind. If any celebrity had to state these words, you're forcing those words on every single person with any sort of public platform. It's an infinite cost. It's an infinite cost. There's no way the court would do this. All right, next. The relative costs and boomers associated with that safer conduct, relative usefulness of that safer conduct. Then there's no use. There's no use. Scottius Maximus I says, if you were Miss Swift's attorney, how quickly could you get this dangerous weirdo committed? Oh man, this guy would have cease and desist requests in every state where he has filed, in every state that he has made a public statement. He would have cease and desist all over the place. And if he sent one more thing to my client, we would be asking police. If you represent someone like Taylor Swift, okay, or Justin Bieber, let's take the sex of the person out of this. If you represent someone who can be regarded as a pop icon, a sex icon, like a Ryan Gosling, something like that, if you represent someone who would be in danger with a deranged fan of sexual assault or worse, then you aggressively represent them. Absolutely, absolutely aggressively represent them. Because, I'm sorry, the odds are that if Russell Greer and Taylor Swift are in the same car, that Taylor Swift ends up in several garbage bags in different lakes, right? Like that's the reality she's dealing with. And you cannot trust someone who is like this. This guy has severe attachment and problem and dangerous issues. The liquor is getting to me. Okay. All right. I said the relative usefulness of the safer conduct and the relative safety of alternative conduct. These 7 factors can be applied to the current case. Well, let's see how competently you apply them, Russell. I have only the highest faith. Duty also depends in part on whether the victim falls within the class of people who are foreseeable at risk of being harmed. Weird pending sex offenders is the class of people we're looking to protect here, I guess. Comparatively, plaintiff belonged to a class of people directly connected to Swift. Listen to the delusion. Listen to the delusion. We're talking about someone who goes on tour around the world and makes $90 million from that tour with hundreds of thousands to potentially millions of live audience attendant fans. And Russell Greer, who hasn't even alleged that he's ever been to a concert, is stating that he has a direct connection to Taylor Swift. Amazing. It's amazing. Amazing. Okay. Her fan base and social media followers. If anybody in the chat, can you just look up what like Taylor Swift's Instagram or Twitter are at? Like let's talk about the class he's talking about. her fan base, social media followers. Please give me an update on Taylor Swift's Instagram or Twitter. Swift should have reasonably known that not having any disclaimers in regards to publicity stunts or statements done commercially, like a music video narration, or non-commercially, like crashing a wedding, could have harmed fans and followers like Greer, who believe said stunts created representations of having similar success. Success? What? Having Taylor Swift crash your wedding isn't success. It's fortune of some sort, but it's absurdly rare. Any reasonable person knows that the likelihood of that is almost zero. Okay, public policy supports a duty. As Satterfield mentioned. Okay, thank you, Alley Cat. Alley Cat has sent. Taylor Swift has 111 million followers on Instagram. Yeah. The idea that Russell Greer thinks he's entitled to anyone. If she were to respond to every fan who sent her anything, she would literally not have enough time in a lifetime to do so. Higgy says, draft the letter, man. 90 minutes past bedtime. I will when I'm done with this one. Sorry, buddy. You can watch it later if you can't stay up. Okay, I gotta go on. I'm not supposed to acknowledge you. That wasn't relevant to this. Okay, public policy supports a duty. As Satterfield mentioned, public policy, Satterfield being a case he cited earlier. I'm skipping the citations because they get really long and boring. As Satterfield mentioned, public policy is to be looked at to establish a duty. Public policy must be well-defined and dominant and is to be ascertained by reference to the laws and legal precedents and not from general considerations of supposed public interest. Russell Greer, you just sank your own battleship, you idiot. Several laws and precedents help create public policy for this case. Do they? Federal laws and regulations state that celebrity endorsers must use disclaimers with products that they advertise and in social media postings related to any paid marketing or products that they endorse. Yes! If it's a paid advertisement, you have to disclose it. It's a paid advertisement. That's nothing to do with you sending an incompetently written and maybe competently performed by someone else song to Taylor Swift. That's not a paid advertisement. You did not engage in an advertising contract with her. And trust me, if you did, you would know who her lawyers were, you idiot, because they would have replied to your advertising contract proposal. Okay, additionally, he brings up singer Pat Boone was scorned by the FTC for failing to make a reasonable inquiry into the truthfulness of his acne medication promotion. Yes, Pat Boone promoted an acne medication that was regulated by the FDA and failed to make a reasonable inquiry into the truthfulness when he engaged in a contract with them to endorse a product in exchange for money. Russell, this is bad! Additionally, the FTC frequently warns celebrities of their social media content and advertising, citing all 47 celebrities who received warnings from the government about their Instagrams, citing Cosmopolitan magazine 2017. Cosmo lost all credibility when they put someone who is 85 times the width of the cover on the cover. Cosmo's done. Go away. And then they made a cake for her to eat, which was just weird. Weird thing to do, Cosmo. In fact, according to FTC endorsement guide, I don't know if Cosmo actually made that cake. Someone made the cake, and that someone should maybe be committed because they are putting that person in danger. In fact, according to FTC endorsement guides, if there is a, quote, material connection between an endorser and an advertiser, in other words, a connection that might affect the weight of credibility that consumers give the endorsement, that connection should be clearly and conspicuously disclosed. Endorser or advertiser, someone who has engaged in a contractual relationship with Miss Swift. If someone sends her a cake and she then crashes their wedding to sing a song at their first dance because she's just a kind of an interesting celebrity who might do that, that's not a contractual relationship. She has no obligation to do it. She's acting on her free will, you weirdo. Tess Hollandaise. Thank you, Harmless Weirdo, for Tess Hollandaise. Tess Hollandaise would be required to disclose her relationship with Cosmo, right? As she's engorging herself on a giant sheet cake that could feed an entire children's birthday party with her obviously photoshopped picture on it, because the king-size bed that she was destroying was barely able to hold her up. Guys, that's one of the most embarrassing videos I've ever seen. I am not a person who particularly cares to fat shame people. She doesn't need to be fat shamed. She needs to be referred to a doctor. A doctor to make sure she's healthy. And she should not be wolfing down an entire cake. No one should. I should never do that. Wilford Brimley has warned us about the dangers of diabetes. So yes, if Tess Holliday was provided a cake as part of her contract with Cosmopolitan, she would be required to disclose that that cake that she was shoving her face into was provided as part of a paid promotion and advertisement on behalf of Cosmo Magazine. Taylor Swift opening a pair of shoes that a fan sent her because they have a foot fetish, Quentin Tarantino, looking at you, buddy, who sends Taylor Swift a pair of shoes and asks her to try them on camera, and she does it. It's a different story. There's no contractual obligation for her to do that. There's no exchange of consideration. There's nothing there, Russell. You should know this. You went to pretend law school. I think, from what I heard, you spend more time in your unaccredited program to become a paralegal than I spent in actual law school. Which, buddy, what are you doing? Okay, unless it is already clear from the context of the communication. Well, there you go. You just ruined your own argument. It's clear from the context of the communication that Taylor has no contractual relationship with someone who sends her an obvious gift. The FTC guides expressly state that the use of an individual's name, signature, likeness, or other identifying personal characteristics, even without accompanying verbal statements, may cause consumers to believe that the entire message reflects the opinion, beliefs, findings, or experience of the endorser. Yes! Yes, if Taylor Swift says, thank you so much for the crocheted goose that you sent me, that's her opinion, belief, finding, or experience. There's no... What are you getting at? These guides serve as great public policy to this case. No, that's not an endorsement of a product, Russell. She chose not to endorse your product. If anything, this is such a self-defeating argument because you offered her a commercially viable piece of material, which would be a song that you could presumably enter into the stream of commerce for money if people would watch it or listen to it. So presumably you provided her a marketable good, and she refused to endorse it outright. Okay. These guides serve as great public policy in this case. It shows influencers are already expected to disclose important information to not mislead consumers or fans. Yes. If she were to play your song, she might want to disclose that it was your song, I guess, but she chose not to. Those who who follow after their words and image in the commercial stunts and marketing that Swift did that influenced Greer, Swift had no disclosures. Her non-commercial publicity stunts lack disclaimers as well. Yeah, they're non-commercial. Further precedent, which is a part of public policy. Do you mean a part or a part? I don't actually know what you mean there, Russell. Has held that property owners and owners of products can be held liable for failing to warn of hidden dangers. She didn't own any property. I mean, she owns plenty of property, but none that's in question here. You did. You did, and you failed to warn me of the hidden dangers of listening to your song and falling in love with you. Swift's publicity and image is her product and property. Courts have described the identity of a celebrity as the fruit of his labors and type of property. Swift maintains her image and is allowed to sue for infringement of her image. Yes, she's allowed to sue for someone using her image to endorse a commercial product without her consent. Because if you say, Taylor Swift really liked my album, you are guaranteed to sell at least one more copy. I promise you. If you lie and say Taylor Swift endorsed your product, you will sell at least one more than you otherwise would have because you lied. That's the endorsement. What? Maddox doesn't understand this. Greer doesn't understand this. How do people not understand this? In contrast, it should be expected that she is liable for any hidden dangers with her property, like other property owners. No, 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 no. No, Russell. No. Image and endorsement has nothing to do with you walking around my backyard and stepping on a bear trap. What is wrong with you? Swift induces fans and followers. No! She has an international influence. For the past several years, Swift used her influence to donate to hurricane victims, donate to gun control groups, and visit the sick and afflicted. What a devil! Listen to how horrible this woman is. Swift shies away from controversial topics. Why would she do that? I don't know. Maybe 111 million Instagram followers who fall on both sides of this, you dummy. Such as politics and religion in an effort to maintain her property and image. No. No. Not in an effort to maintain her property and image. In an effort to increase her exposure and likability amongst fans. You idiot. Which is not property. That's a social property. It's not a legal property. The hidden danger with her property and representations is the amount of sway and influence behind them. No, no, no. Those aren't hidden. You're talking about how obvious they are. They're not hidden. With no clarifications or disclaimers attached to the marketing or to her opinions, which can become fact. Russell, if you're still out there, please come on my show. Please, I will beg you, I will pay you, I will do whatever to talk to you about this. Russell, come on my show. I will give you the fairest interview you will get anywhere on earth. Please, Russell, please, please, please come on my show. Zidane, we are drinking the aura of Russell Greer. That's what we're drinking, buddy. And this is a Kirin Japanese whiskey. Okay. Okay. The hidden danger with her property and representations is the amount of sway and influence behind them with no clarifications or disclaimers attached to the marketing or to her opinions, which can become fact. How can her opinions become fact? Given her level of influence, statements of opinions can be seen as statements of fact. Yeah, if there's... Russell, buddy, that is not how that works. Okay, what he's talking about is a statement of opinion of someone with enough social credibility to determine the opinion to be a statement of fact. Let me give you an example. Okay? Marilyn Monroe says, L'Oreal has increased my attractiveness and will certainly increase your attractiveness as well. That's an opinion that can be taken as fact because of a contractual relationship between Marilyn Monroe and L'Oreal to advance a product that is hair dye. Okay? Seriously, that's what they're talking about. That's the opinion that can become fact. Duty extends to third parties. The Sixth Circuit has held that it is not required for a plaintiff to have, quote, a link such as privity. Privity is a chain of contractual relationships, okay? So, let me lawsplain. I don't get to do this too often because some of this stuff is pretty basic. Privity is a term of art. Privity is talking about your relationship of contract. So if I am talking to you, let's say I am a landlord and you are someone who is, how do I do this? You're someone who is dealing with my tenant. Okay, you're dealing with my tenant. Like you slip on my tenant's property that he's renting and you fall. You're in privity, or my tenant is in privity with me because we have a contractual relationship that is outside of your relationship. You don't have a relationship to me because I just rent a property to someone else. But my tenant is in privity with me. So he has a contractual obligation. And that privity of contract may advance liability from my tenant to me because I am the property owner. I take various insurance out and I undertake risks as a property owner. So if you slip and fall on property that I pay for and own and pay the property taxes on, well, then maybe your claim is against me and not my tenant if it's my duty to maintain the property in a particular way, or if I have failed in some other thing, like I put a bear trap on the property to catch bears and you stepped on it, right? The privity of contract between me and the tenant may allow liability to me for your relationship with the tenant. That's how privity works, okay? So let's read back that with the understanding of what privity is. The Sixth Circuit has held that it is not required for a plaintiff to have a link such as privity. Okay, so it's not required to have privity of contracts, a bond approaching privity, so something close to that, or a fiduciary, so a monetary relationship with the defendant in order for a duty of reasonable care to exist. Right. You can have a duty of reasonable care to someone who you have no other relationship with. And think about it this way. The example I just gave. If I put a bunch of bear traps on my lawn and I know that kids run across it, but I hide bear traps on it and one of the kids get injured, I don't have any privity with the party. I don't have any privity with that child or the parents of that child. But I may have a duty of care to not put bear traps or to clearly mark the bear traps because bears can't read, but people can, to clearly mark the bear traps. Or I might have an obligation to not put bear traps where I know children are present. Those are the obligations they're talking about here. Without limiting its holding to a particular group, the court reiterated the well-developed negligence rule that a defendant owes a duty of care to all those who are foreseeable as a potential class of injured persons. If kids are running all over your lawn and you decide to put bear traps on it, the children are foreseeable victims of the bear trap. Okay? Yes, the privity of contract would only extend to my tenant, but that privity may impose liability upon me to an outside third party. So hopefully that clarifies that. I'm going to drink something else. Guys, look at this. This is the saddest thing on my shelf. This is the end of the Basil Haydens. Longneck McGee says Nick lost his brother in the Great Bear Trap War of 2001. Real talk, y'all. I never had a brother. I have a sister whom I love very much. She's an older sister. She's 5 years older than me. We have great times together. I love my sister very much. We have great conversations, great fun. But I never had a brother. Always wanted one. Jacob Cerizia, Rekieta sidebar. Which is the better hot sauce between Chula and Tapatio? I've got to go with Tabasco. And someday I'll tell you about my family link to Tabasco. Just a second, guys. Just a second. I didn't want this in the video, but I'm getting feedback from Lady Rackets. All right. While I wait for her response, we will carry on. We will carry on. Okay. potential class of injured persons. And now he is italicized and bolded this, so this must be important. And all those third parties who defendant knows will rely on the information. Lady Rackets is helping me out. She is apparently watching the stream. Thank you so much, Lady Rackets, for looking out for me, as you always do. I love you very much. She has brought up a good point. I have lost track of how many liquors I have consumed, and this will be my last liquor of the evening, which is more than enough. And I will talk about that later. Okay, all right. So, I know there's someone in the chat right now who will appreciate the citation, so I'm going to read it. Cleveland Indians baseball versus New Hampshire Insurance Company. Examples abound of well-cited cases that have been used in the Sixth Circuit to establish a duty to third parties. But not like this, Russell. Not like this. Not like this. Not like this. Hanbury versus Harst was cited in the complaint. Good job. Good job, Russell. Defendant Taylor Swift may be playing a character. And Lady Rackets is calling me out saying, I don't remember specifically how I said this, but I said I'd help someone kill themselves, which is not funny. And that's true. That's true. I may have gone overboard on that joke, and I apologize for it. I apologize for it. Thank you, Lady Rackets, for keeping me accountable. Okay. I don't actually want anyone to kill themselves. So if that joke got translated literally, I apologize very much. Humbly. And guys, if you're out there and you don't have a good wife who will keep you accountable when you step over a line, that's what a good wife will do. That's what a good wife will do. So anyway, let's move on. Taylor Swift may be playing a character as a persuasive factor in deciding duty and damages. It can easily be argued that defendant Taylor Swift is playing a character. Okay. Publicity stunts Swift has done may have been done for show, that she doesn't actually mean anything she says, and thus warrants a disclaimer. I think that is a stretch. That is a stretch. That is absolutely a stretch. This is readily proven by the bio on Swift's Instagram accounts, which read, "The old Taylor can't come to the phone right now." And she's... If I'm right, and I don't follow Taylor Swift that closely, I love her music, although I like her older music a little better. But she's talking, Reputation, I think, is the album that he's referring to, and Taylor Swift has changed dramatically from a young, aspiring country artist to a pop artist to now something that is genre transcendent, and does features and everything else. Like, the full pop experience is happening, and I'm actually not a fan of all of those songs, right? Like, I love the ballads. The ballads are important and good, and they evoke emotional responses. I'm not sure, even going to the song Reputation, I'm not quite sure that it does the same thing. Okay. And Lady Rackets further clarifies that I said I would help him write his suicide note. And I think I did, well, I know I did say that because she told me I did and she wouldn't lie to me. So I apologize for that. Russell, I don't actually want you to kill yourself. It's an internet meme. And I apologize for stepping over the line. I really, really do want you to come on my show, and I want you to talk about this. I think it would be great. I think you're way wrong on the law. I think you have some really weird ideas about what celebrities and women owe to you. Absolutely. And I think we could talk about those. I think I can help you, buddy. I think I can help you. I literally don't want anyone to commit suicide. That's a joke that maybe I got carried away with. All right. Anyway, as a persuasive factor in deciding duty and damages. Oh, wait. Playing a character. I read this. Below, the statement is a link for tickets to her concerts, which clearly shows that her profile is a business account. Well, absolutely, her profile is a business account. This character argument is a similar one used as a defense with infamous conspiracy theorist Alex Jones. Okay, he's referring to Alex Jones's divorce, in which Alex Jones alleges that, no, I'm not actually crazy. This is literally a character. And guys, if you haven't read that, maybe we should talk about Alex Jones's divorce documents, because they will cast... Think about it this way. Alex Jones cast significant doubt on his own character because he wanted to be with his kids, and it got ruled against him, and that kind of... That's a frustrating topic. No particular love or hate for Alex Jones, but what happened to him in court is a little bit frustrating. So we'll talk to that. We'll talk about that at some point. Okay. Whose lawyer argued that Jones was a performance artist playing a character, and that he didn't mean controversial statements that he made, and this is citing NBC News. InfoWars, Alex Jones is a performance artist, his lawyer says in divorce hearing. There's a big difference between statements made by Alex Jones as a performance artist and statements made by Taylor Swift as a performance artist. If Swift is just acting and faking with her stunts, she needs to disclaim so. No, she doesn't. No, she doesn't. She doesn't need to disclaim so. Notice there's no authority cited for her argument that she needs to disclaim that those stunts are a thing that she's acting about. There's no authority cited for that because it's not a real thing. There are no disclaimers with any of her postings or stunts, etc. You're calling them stunts. Presumably alleging that Taylor Swift only acknowledges gifts that she got out of a desire to increase fans' viewership and income rather than a genuine expression of gratitude. And that's a hard sell, man. That is a hard sell. If Swift is just acting and faking with her stunts... Oh, wait, I just said that. Breach of duty. With the duty established in the above-mentioned points, Swift breached her duty by failing to use disclaimers. As shown in Exhibit B, there are no disclaimers in any of her posts or on her profile, as her profile is clearly for marketing her product, which is her music and her likeness. So what? That's not a breach of duty. Okay, pardon. He's alleging that she has a duty and that she has breached the duty, and the duty is to disclose something. He hasn't properly alleged a duty. A judge would rip this up. An opposing counsel would rip this up if he could figure out how to serve it. The opposing counsel would rip it up. Commercial publicity stunts. There were no disclaimers in her commercial publicity stunts, like for the promotion of a movie, which she wrote the theme song for. She does a voiceover in a promotional for the movie and describes the protagonist's struggles of trying to get into the entertainment industry inspiring. The spoken representation done for commercial marketing swayed Greer to believe that Swift would be open to his efforts and story of struggles of living with a disability, trying to get into the entertainment industry. Her statements made it seem that she was open to all kinds of inspiring stories. I'm not familiar with what he's talking about here. We'll have to see what he says in Exhibit C. Similarly, with her music video New Romantics, Swift does a voiceover accompanied with a montage of waving fans and says, "The fans are the best part of this tour." What's wrong with that? Clearly done for promotion, not necessarily. Not clearly. That could simply be an expression of gratitude a statement of fact about her state of mind at the time. It is not clearly done for promotion of her music and product. This influenced Greer to believe that she would be welcome to his efforts because he was a fan. No, she did not say, I will recognize every single fan who sends me anything. That's a different question. Since her statements were made commercially in promotion of her movie and music, her statements of opinion became statements of fact. No, Russell, no. Swift has done many other publicity stunts, which weren't commercial in nature. But because they still created powerful representations and because they were posted to Swift's business profile, they swayed Greer and she breached her duty to have disclaimers. She doesn't have a duty to have disclaimers, Greer. No one has a duty to have disclaimers on this stuff. They have duties to disclaim products that are paying them for an opinion. It's a vastly different thing. Vastly different. As they created representations of fact. One stunt was a photo of Swift who had been invited to a non-famous person's wedding and she accepted. This created a representation that Swift was open to having fans reach out to her. Even so, she can have fans reach out to her without creating a duty of her to perform on whatever they ask. On another occasion, which was carried by the news, Swift paid for her background dancer's niece's hospital bill. This created a representation that Swift was a kind, giving person. So, that doesn't mean you can compel a kind, giving person to perform. She had a relationship with a direct relative of that person. There's huge differences here. On another occasion, Swift accepted prom invites from high school boys. Swift has had a long, documented history of swaying and creating representations without any disclaimers cautioning anybody she may have swayed. Lack of commercial context with these stunts shouldn't matter. Because many non-commercial groups and persons have disclaimers with any charity that they do. Yeah, they want to be clear that they're representing a charity, often as a paid representative, because charities know that they could pay someone like Taylor Swift to come out and endorse their charity and get much more traction than they otherwise would. For instance, with legal pro bono work, law firms will have criteria listed as to what they consider. Many charity organizations will have disclaimers with what they will help out with and what they won't. Russell, you just broke a critical rule, an absolutely critical rule of writing a legal pleading. You never have a contraction in a legal pleading. Will not. Not won't. Don't use won't. All right, both contexts of commercial and non-commercial stunts show that Swift's words, actions, and likeness have adequate disclaimers to have prevented the harm plaintiff has suffered. Swift breached her duty to have disclaimers given public policy precedent. No precedent has been cited that has in any way related to a public figure making public opinion statements outside of an existing contract. Not a single shred of precedent supports your position, Greer, and the amount of influence that Swift has. Swift should have foreseen the harm. Swift should have easily foreseen that with 111 million followers on her social media, he did it for us. He did it for us. At least one follower would have been swayed by her commercial and non-commercial stunts and would have suffered harm by reaching out to her and discovering that her representations were not what she intended them to be. No, Russell. No. Bad dog. Bad dog. Get out the newspaper and hit yourself. She didn't intend them to be that way. You presumed she intended them to be that way. You're the only person. Swift should have foreseen that disclaimers would prevent followers from suffering harm. I can almost guarantee you that any amount of disclaimers that Taylor Swift put on her products would not have stopped you from sending her a song. You're lying, Russell. Even with the chain reactions that followed, Swift should have foreseen that trolling is real. And there are those who prey upon others with unique views, and said trolls would harass certain people. Taylor Swift has no obligation for the trolling of you, Russell. Except for in regards to this stream. Taylor is fully responsible for all statements made in this stream. Let's be very clear on that. It's her fault entirely. We've never talked about this. I've never had any conversation with Taylor Swift or her counsel, but I'm just going to say that she's responsible for everything that happens here because apparently that's how it works. One way that Swift could have foreseen harm is how people try going viral, which means a person posts a video with the hopes that it gets a lot of views and clicks. Swift has noticed several people this way. Unfortunately, several people who try going viral end up having their plights end up on troll sites. Russell, you don't try to go viral. You either go viral or you don't. That's how it works. Going viral has a certain genuine quality to it. Like, that's what goes viral because people resonate with reality, not with contravention. And maybe some of them are contrived. Absolutely. I'm going to say absolutely some are contrived. But the ones, they don't try to go viral. They just end up going viral. Okay. Sites where people around the globe make it a sport to belittle and bully random strangers. And no one should be belittled and bullied except maybe someone who thinks that he can force women to sleep with him through the law. You need to be belittled and bullied for that idea, Russell. Swift apparently advocates against bullying, and so she is aware of trolling. This is what happened with plaintiff. Swift apparently advocates against bullying. Oh, wait. Swift should have foreseen that by not utilizing disclaimers, people would try getting her to see their plight and have their stuff end up on troll sites. No. That is not how it works. Is not how it works. Welcome to the chat, Kiwi Farms. These are all harms that Swift could have easily foreseen. Russell, they're harms that you could have easily foreseen. Swift's breach of duties listed are the proximate cause of plaintiff's damages. The Sixth Circuit has held that a negligent defendant is generally liable for all injuries resulting directly from his wrongful act if the damages were the legal and natural consequences of his conduct and might have reasonably been anticipated. Greer now presents all damages resulting from Swift's breach of duty. Many of the damages shown are layouts. Layout is one word, Russell. And glances of damages, as that is what a default is for, is to show basic evidence to support his claims. If a default judgment is rejected and a trial is instead warranted, discovery through subpoenas, statements, and more pages of damages can show more in-depth damages. Russell, the last thing on earth that you want is your default judgment to be rejected and a trial being warranted. A trial being warranted. The one thing that you absolutely want is for a judge to dismiss your action with prejudice, with costs resting on the parties. You definitely do not want to go to court with Taylor Swift on this because you will be responsible for her attorney's fees, and her attorney is more expensive than your not attorney. General compensatory damages. Economic loss. Plaintiff has lost 4 years of his life. That's a bit of an overstatement. Being entangled in this mess and the representations of Taylor Swift. No. You lose 4 years of your life in the pit of despair. Not by writing a song, Russell, that's gotten you more attention than anything else you could have possibly done. As stated in his complaint, he relied on Swift's representation starting in 2014. He dedicated his time, money, and fundraising efforts into producing a song about Taylor Swift, a gift made in reliance on her previous stunts. Russell, even if she had directly promised you that she would listen to your song, like in person, promised that she would listen to your song and play it or whatever. Promissory estoppel in a direct statement is extremely difficult to prove. Without consideration, contracts are hard to create and hard to show. You're saying that she created promissory estoppel by never interacting with you. That's an amazing claim, and you're definitely going to lose. It only goes against 500 years of property law and contract law. Only 500 though. Only 500 years of it. With the hopes that he would have the same success that others had. It wasn't his best work. Why wasn't it? You spent 4 years on it, buddy. Due to hiring fraudulent production companies. But it still showed genuine effort. It's a part of having a disability that motivated Greer to undertake his efforts of wanting to be accepted and helped by somebody so he could be so much more than the limitations that he lives with. And again, those limitations are horrible, buddy. I legitimately feel sorry for those limitations. It's not your limitations holding you back, though. It's not your physical limitations holding you back. It's your ideas that other people owe you things that should never be owed to anybody. That's what's holding you back. His invigoration was sparked by being denied on a reality show. I'm guessing that's America's Got Talent. And hitting walls with agents in the industry. Not everybody makes it. And your disability doesn't give you license to make it, buddy. It just doesn't. You've got to find other things to do. You were a paralegal. Maybe go back to that. I don't know if you ever can. Yes, Kiwi Farms. It is normal for pro se defendants to refer to themselves in third person in a legal document about themselves. Yeah. Okay. Put simply, he saw her help others and saw her make commercialized representations that she would be open to such an ambition. No, you projected that upon her, buddy. She didn't say, listen, I'm representing that I'm open to you sending me a gift and me reciprocating in some way. I don't think she ever said that. Maybe she did. At the very least, Greer hoped for acknowledgement. We know. Greer burned bridges with his college paralegal program director who gave Greer an ultimatum to choose between flattering a celebrity or being a legal professional. He didn't give you an ultimatum, Greer. He gave you advice as someone who helps people get jobs in the legal profession. He said, look, man, you got two choices. You can go after Taylor Swift, or you can go be a paralegal, which you just worked really hard to become. You've got those two choices. Chose the wrong one. Program director thinks of Greer as unprofessional now and doesn't help him find jobs. I wonder why, Greer. As an alumnus of the college, former college-level professors of Greer avoid him. Absolutely. Of course they do. You're a walking sideshow. Greer's first professional job, Trask Britt fired Greer, in part because they felt it was unprofessional for him to reach out to Swift. Greer, you're writing your own resume on why you shouldn't be hired right now. Charlie Doe, office manager of the firm, terminated Greer. Further, no other entertainment people want to work with Greer due to this series of events. Right, because they're maybe afraid you might sue them if they don't answer an email. Agents show interest in Greer and then they go silent. I'd be curious about what agents show interest in Greer. Like they discover this horrible person when Greer isn't a bad person. That's debatable. Some of your positions are abhorrent, my friend, and you might need to rethink them. Again, come on my stream. I'll help you talk about it. Greer is possibly blacklisted from Hollywood. I doubt they care who you are, buddy, because of this entire incident. And even if you are, You're blacklisted because of your actions, not because of a belief, not because of a protected status. Pirate Chan says, hello, I've had 5 shots, 2 beers, and 2 9 milligrams THC gummies. What is going on? Buddy, I don't even know. I don't even know. Gaston Heap says, Maddox and this guy should get drinks together. They can both come on my show at the same time. I'll help them both out. I'll help them construct proper legal opinions. And then they can determine if they want to pursue their legal opinions at that point. Okay. Economic damages also extend to the next point of damages. Economic damages are recoverable in a negligence third-party action per circuit case law. Sure. Sure they are. Reputational damages. Greer's largest point of damages is a ruined reputation. Besides being let go from jobs and ruining his academic connections early on and relying upon Swift's representations, Greer's efforts began to catch the attention of bullies and cretins, commonly referred to as internet trolls. Cretins. Or to pronounce it as Ann Coulter would pronounce it, cretons. And that's something between a cretin and a crouton. One is kind of a dumb person who goes on doing offensive things, and the other is a toasted piece of bread that you put on a salad. It's cretin, not creton. I don't know how Ann Coulter has been alive and in the public eye as long as she has without being able to pronounce cretin. Look at these cretons. Cretons are probably something you encounter in Star Trek as Captain Kirk and try to bone. All right, let me go. Let me go back. Who began to harass Greer. These are the cretons who began to harass Greer through social media, calling him too ugly to see Taylor. And Greer, that is offensive, but it might also be real. Look at the people Taylor Swift dates and associates with. They're celebrities because she makes $90 million a year going on tour singing, right? They began creating posts on Reddit of Greer through the sad cringe section. Wah, 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 wah. One of the first posts created of Greer on Reddit was a post saying the only thing Russell Greer and Taylor Swift have in common is that they both play victims. Well, that's about the fairest first post I can imagine. And Ascending Fire brings up a good point about cretins. Cretin is a slander or a slam against people who are from the island of Crete. You can even find insults in the Bible of cretins. So, people from Crete, according to the Bible, are like a rowdy irascible bunch that you don't want to associate with. Check out Titus if you want to learn about Paul's opinions of the Cretans. The defamation only increased thereafter. Since his efforts caught the attention of trolls, they use any sort of misstatement Greer makes against him, or they fabricate events that never happened, or they exaggerate who Greer is. Why would you ever exaggerate who Greer is? You could just read his words. They're horrible enough. His verified words and complaints that he files all over the place. The trolls began harassing Greer's place of employment, patent law works, and started emailing lies about Greer. And that is unfortunate if they're lies. As Maddox said, never go after someone's livelihood. That's just a dirty move. And remember, Maddox said that. And Maddox is right. Don't go after people's livelihood. Don't lie. Don't send emails to people's employers and lie about people. Maddox said that's a bad thing. The human resources manager wouldn't hand over evidence for this motion. Did you properly subpoena the evidence, Russell? But plaintiff declares under penalty of perjury that one email sent to the HR manager as told to Greer by the manager was an email that had a picture of a phone that had pornography on it, which said, Russell has been looking at porn on his work phone. The email was a lie because Greer didn't have a work-assigned phone. Then, Russell, I'm guessing that the HR management did not rely on a picture that said that you had been looking at porn on your work phone if you didn't have a work phone in making their termination decision against you. What? Anonymous people had set out to destroy plaintiff Greer. Yes, that sometimes happens, and it is unfortunate. It's a byproduct of the internet and the freedom of speech. If evidence or testimony is needed in the form of a subpoena, if this proceeds instead to a trial, it was told to Greer that hundreds of emails were sent to his former HR manager with lies about Greer. And yes, Greer, you could subpoena those. You could subpoena the production of those emails. The manager, Jennifer Nikeo, even told Greer that he, quote, had made some enemies. Greer was bewildered because he hadn't done anything wrong. Greer and Hitler, right up there in the same class. Oh boy. Greer didn't do anything wrong, guys. Okay. Around this time, Taylor Swift's agents were negligent with handling Greer's musical gift. They believed that Greer... Oh, he doesn't mean his musical gift like he has a gift for music. He means literally the musical gift he was giving to Taylor Swift. I apologize for misunderstanding what he was saying. I apologize for misunderstanding what he was saying. Okay. They believe that Greer was trying to get Swift to have her do a song. No. Russell. Taylor Swift is $100 million a year recording artist. She cannot, as a basic, obvious policy, accept any submissions of music, whether you're trying to give her a song to perform or whether you're trying to give her a song as a gift. Because if she accepts even a gift and then does anything with that resembles the song that you would have written and given to her, even in a portion of a verse, if she takes any idea that could be linked to that song, you might have a copyright claim against her that would be worth millions of dollars because of how successful she is. So she adopts an obviously reasonable policy to not accept any musical contributions for the risk that any acceptance of a musical contribution might create liability in a copyright action. You know this. You have to know this. It's the most obvious legal play she could possibly make. They somehow refused to understand that he was trying to give her a gift. They didn't refuse to understand that. They understood it explicitly and told you she will not take any musical submissions. Ascending Fire, no, it's not hearsay at this point because he could subpoena the law firm for anything that they would have. He could subpoena them for that information. Absolutely. The same kind of gift she was trying to receive in the past, or she had received in the past. What is important to understand is that this gift wasn't a cover of one of Swift's songs. That's not important. It is irrelevant to this. Is irrelevant. It wasn't an instrumental version of her song. Irrelevant. It was an original song that was meant to be a gift. That is actually the most important and relevant thing, is that it is an original song that then is not a derivative work of something else and not a cover covered by a mechanical license for covers. It simply would be a new creative work, and then if she did anything that resembled it, it would put liability on her. It's an original song that was meant to be a gift that talked about how Taylor's music had helped him. Great. You just put it out on SoundCloud and tweet it out. That's what you do. You don't send it to her. They mention contracts and unsolicited song submission policies and how Swift writes all of her own music, which is irrelevant. No, it's the most relevant. Improved negligence. No, because Greer was trying to give a gift. Thus, none of that mattered because there's a difference between a gift for her to have and a song for her to do. No, there isn't. Not from a liability standpoint in copyright. At the very least, he wanted his story of trying to overcome his disability passed on. Then you should have written a book and given it to her, Russell. Not a song. Literally, you could do any other gift than a musical gift. He'd be just fine. And she'd probably accept it because Taylor Swift has a habit of accepting gifts. But even if she doesn't, that doesn't impose liability on her. Oh, she asked how my favorite blackface lawyer feeling tonight. Feeling great. Probably a little too intoxicated, which I have been sufficiently called upon by Lady Rackets. So, they mentioned, okay. At the very least, he wanted his story of trying to overcome, his disability passed on. Somehow the agents didn't understand this. No, they understood it perfectly. And for some reason, it brought out trolls who embarked on a mission to destroy plaintiff Greer. It would have killed Greer to know that he gave his all after relying on Swift's representations and that she never saw it. It would not have killed you. You're still alive. How would it have killed you? That's a lie. Especially in light of the harassment. So Greer looked for other ways to get it to Swift. He contacted associates of hers. Greer, she still hasn't heard your song. And she likely never will. Her record label and her IP law firm. Nobody seemed to want to help him. Wow. Welcome to the world, Russell. Welcome to the world. After studying cases on Google Scholar... Greer found a case for vicarious liability, which stated that suing under vicarious liability reflects the likelihood that an employer will work a problem out. The restatement third of agency. With Swift's representation, she portrayed the likelihood of success of a problem being resolved would be realistic if she saw said problem. Who is Taylor Swift an agent for? Oh, you're saying her agent, like her agents are agents for her as principal and that they should have worked this out. They did work this out. They just said no. Google 2 says, for some bourbon or some coffee. Thank you, buddy. I appreciate that. This was reinforced by... With Swift's representation, she portrayed the likelihood of success of a problem being resolved would be realistic if she saw said problem. This was reinforced by Exhibit F. Her dancer showed her a problem that he had, and she also fixed it. No. Also, Swift has been the subject of ridiculous lawsuits, and she has responded to several lawsuits. So Greer relied on this and sued her for the conduct of agents, as explained in the complaint. When Greer told one of his friends what he was doing, Greer began crying because he didn't know any other way that she would see his efforts. Greer filmed 2 videos of himself and sent to Swift's agents explaining the purpose of the lawsuit. Second video is made to clarify misstatements that he made in the first video. All those poor agents. Also, the lawsuit was citing a state statute that required registered agents to act in the same competence and manner that other agents would act because Greer believed that any other agents would have taken the time to learn that it was a gift Greer was trying to pass along and not a song for her to do. Thus, the lawsuit was not frivolous. No, the lawsuit was frivolous. I'm pretty sure the judge told you it was frivolous. Greer. Weeks later, Swift's lawyer in Utah, Greg Skordas, I gotta get Greg on for an interview, wrote a motion to dismiss, and according to the legal document, Taylor Swift was perturbed by Greer. Greer was crushed. Not literally. A piano did not fall on Greer. I want to be clear. This is a very musical case, and it's ridiculous enough to be Acme certified, but a piano was not hovering above Greer that actually physically crushed him. He's talking about emotionally crushed. This is another example of Swift's representations leading Greer on. No. She's perturbed by you. That's not leading you on. You're a creep. Leave me alone is not an invitation to come at me more. Without these representations. Oh, wait. Sorry. This is another example of how Swift's representations leading Greer on and causing him to engage in action based on her statements and likeness. Go away means please come at me. Without these representations that Swift has made, there would have been no likelihood of a problem being resolved. Thus, the lawsuit would have never been filed. I doubt that. I doubt that thoroughly. Greer would have never gone to extremes to try fighting for the efforts he worked on, and Greer would have no reason to have had complaints with the agents. Ironically, Swift slandered Greer. Guys, bets on ironically being used improperly. I'm going to give the odds at 70-1 that it's used improperly. Ironically, Swift slandered Greer for him relying on her representations. This is not irony. Greer has to take the words in the motion as true, as the lawyer and other professionals wouldn't have lied about words Swift said. Good. They probably didn't. They probably didn't. They're probably 100% truthful that she said that she was disturbed and shocked by you. As iterated in the complaint, the previous lawsuit does not preclude claims here, as Greer is arguing claims based on Swift, not her agents, which is the small claims lawsuit argued. That actually doesn't matter because principal-agency relationships put the principal as the liable party. So you are actually reiterating the exact same claims against Swift that you were in the prior ones. You're just taking out the proxy that was acting on Swift's behalf. So you're wrong on that too. Collateral estoppel. Collateral estoppel is a civil version of double jeopardy. Prevents relitigation of factual matters that were fully considered and decided in a prior proceeding. Thus, collateral estoppel operates to prevent repetitive litigation. No arguments for duty to warn, failure to warn, or anything based on Swift's conduct were ever brought forth in the lawsuit. That doesn't mean that you're precluded from bringing them now, because we have claim preclusion, which you're talking about, and we have issue preclusion, which is you failed to bring those claims in the litigation of the issue. So you still could be precluded under issue preclusion Greer. I know you covered this in your civil procedure class, but you must have been asleep or drunk or dead or whatever that day. Also, the claim was filed in small claims justice court, not a state or federal court, so the judgment, which is based mostly on lack of jurisdiction, wouldn't affect this case even though no similar claims are brought here. Not necessarily. Not necessarily, Greer. You can make that argument. The court doesn't have to accept it because you had every opportunity in that small claims justice court to raise all of the issues in a sufficient pleading, and you chose not to. You've asserted your own expertise so much that you may have actually created a burden upon yourself to proceed as a respected professional and not pro se. Maybe. I don't think so, but maybe. Maybe. Quote, requires a federal court to accord a state court judgment the same preclusive effect that the judgment would have in state court. Justice court is different than state court, and thus no preclusion applies. That is not true. You can actually get a final resolution in justice court. You can move the court to vacate a justice court decision, and the court can refuse that motion. So you're not actually right there either, Greer. Lastly, rulings are found to be invalid when it is found that the judges have a bias. Okay. Several witnesses saw and are willing to attest, if this current case goes to trial, that Judge Havas of the Small Claims Court of Salt Lake City was hostile and intolerant of Greer. It's because you brought a frivolous lawsuit against someone, and no one should have to deal with that. The judge didn't let Greer show any evidence. That's because you're being dismissed for lack of jurisdiction. As you just said, if you're dismissed for lack of jurisdiction, you don't get to present evidence. The judge laughed at Greer, and you deserved it. You absolutely deserved it. Absolutely. The judge rolled his eyes at Greer, and you deserve that too. Again, here, let me help you. There, I rolled my eyes at you. The case was very embarrassing. because nobody understood the vicarious arguments, even though Greer presented solid claims. Greer, if you present claims to learned individuals like a judge and they just don't get it, maybe your claims are terrible. Maybe they're terrible. Presented solid claims of the agents being obtuse with handling the communication. No, they presented a clear and illicit policy that they don't accept music. Greer had evidence of emails telling the agents how he thought it was unfair for her to accept gifts from random people but not from him, which proves he was trying to give her a gift and not a song for her to do. It doesn't matter. It doesn't matter. The judge wouldn't let Greer show this. It's because it doesn't matter. The evidence would have helped show that Greer was trying to do and display the agent's negligence and shown that Swift was liable for their negligence because she failed to work with them on instructions on accepting gifts. There seemed to be communication conflicts between the agents and Swift. Buddy, no. Guys, this is having like a 6 of clubs as the high card in your hand. No, 6. Yeah, 6 of clubs is like the lowest high card you could have without having a straight. And saying, no, I'm definitely betting everything because you just don't understand how strong of a hand I have. Like, that's what Greer's doing. Newspapers and news stations around the country. No. It'd be a 7 of clubs. Right? Like, because if you had a 6 of clubs, that would require an ace to 5 split. Yeah, because if you had an ace, you would have an ace to 5 straight. Okay, so if you had a 6 as the high card, that would mean you would have a 2 to 6, which would be a straight. So a 7 high card. Let me correct that, okay? I don't want to go on record here making bad, Okay. Sorry for that digression. I just had to make sure that it's a 7 would be the lowest possible high card hand and not having an otherwise better hand. Okay. Newspapers and news stations around the country and the globe picked up Greer's lawsuit and purposely smeared Greer. The news purposely omitted the vicarious liability arguments. No, it's just that they talked to any attorney ever and said, no, this guy doesn't have an argument. This guy doesn't have an argument at all. What is he even talking about? And failed to mention Greer's disability, which doesn't make you have an argument. Ask Molyneux. Here, let me do. Listen, guys, it's not an argument. I can't even do a Canadian accent. Molyneux would tell you that's not an argument. Having a disability does not make your argument more or less credible, Greer. Or other motivating factors that would have not painted Greer into a raving lunatic. Nothing would help you. You are a raving lunatic. But the newspapers were fueled by Swift's slander in the motion and the hostile tone that the lawyer had. A newspaper in the United Kingdom called Greer entitled, "How Dare They?" What is that? The worst thing that you could come up with that they called you was entitled? A Utah news station smeared Greer as frivolous. Greer himself is frivolous. This human is frivolous. The news refused to correct statements that they had published or even refused to reach out to him for a comment, which furthers the smear. They put in false information about Greer, such as he was suing her to go on a date. Oh, the truth hurts, Greer. Nowhere in the lawsuit was there mention of a date. It's because, Greer, I'm pretty sure your version of a date involves a burlap sack and a trunk. However, in the first video Greer sent, he made a misstatement and said he worked on the song with the hopes that he could have similar success as other people, such as going on a date. So he literally said... I literally said, I'm doing this for a date. But how dare they say I'm doing this for a date? He felt that this was unclear, and so he made a second video which clarified what he meant. The news didn't mention this and deliberately put that lie in their newspapers, which is defamation. The hostile news attracted more trolls who put Greer onto various websites. List the websites, Greer. List them. One website, Kiwi Farms. There it is. He just goes ahead and points it out. Why would you actually list the website? Don't do it. Don't do it. Kiwi Farms, I'm going to expect some remediation for the free advertisement. Is a troll site mocking those they deem to be weird. They refer to people as lolcows. No, they refer to very specific people as lolcows. Said site has over 100 pages on Russell Greer. The troll sites made the incident worse than it was. It couldn't have been worse than it was. The owner of Kiwi Farms, Joshua Moon, hashtag doxed, who goes by the name Null on the website, has refused to comply with a request to remove Greer from the website. It's over 1,000. It's over 1,000 pages. Technically, he's right. It is over 100. It is over 100. The site has gone from mere defamatory statements to putting Greer's copyrighted material on that site. Publishing Greer's addresses. Greer, are they just posting the court documents you file that has your address on it and your phone number? Why didn't you request for those to be confidential based on the trolling you've received? You could do that. You could absolutely and easily do that. His family's contact info, his friends' info, under the Communications Decency Act. Are you seriously citing U.S. I think it's, 47 U.S.C. 230, Communications Decency Act? Site owners are not liable for third-party conduct. A fact Null proudly touts. No, Null does not make editorial decisions about what goes up on Kiwi Farms. So he has immunity under Section 230. It's not just Null. Facebook, Twitter, everybody else uses that. Guys, the extent of CDA 230 is massive, and I'm going to be talking about it soon, hopefully with YouTuber Law, because it's a crazy subject. It's crazy. Even if Greer could sue Null, the site owner doesn't have the monetary value to compensate for the harms Greer has suffered. No, you're too poor for Russell Greer's blood. Oh my God. This site engages in a practice of malicious harassment. Null is hashtag too broke for Greer. Several people have tried coming to Greer's defense on that site. Have they? Have they? Ludwig World Order, first time viewer, tuned in for the Greer lawsuit. Russ Hole's KF thread is hilarious. I bet it is. Several people have tried coming to Greer's defense on that site, only for them to be blocked and to have a message sent to them saying, "You're stuck here forever." This site has had users create fake profiles of Greer and they send him friend requests. Oh my goodness. Some profiles created have been... Russell, I can't swear on this channel. Poop Lips Greer. Rat Face Russell Greer. That's rude. That's rude. Rats can close their mouths. Russell can't, and it's mean to equate him to a rat. He doesn't look like a rat. He looks like a person. Another profile had put Greer's face on the guy grabbing Taylor Swift's butt. Russell, wouldn't you? Like, we know you would. maybe not. Maybe you just want the girlfriend experience. I don't know. But I would be surprised if Russell Greer in a room with Taylor Swift doesn't make that grab happen. Some of these users have impersonated famous people. How dare they? And stolen personal, intimate photos of Greer. After coaxing Greer into believing he was talking to said celebrity. No. Guys, I need help here. Did Russell Greer respond to please send nudes with nudes? Did that happen? Yeah, Russell, I'm totally Ariana Grande. Please send nudes. Why? Oh my gosh. Is this the real life? Is this just fantasy? Sending my nudes like Ariana Grande wanted me. Oh, okay. Another person left a voice message on Greer's phone and pretended to be Swift's record label. One person pretended to be pop star Katy Perry and stole intimate items of Greer's. What intimate items did they steal? Oh my gosh. The Eight of Spades says, don't forget, you're here forever. They later posted said items on troll platforms. That's Exhibit Y. Did he send the intimates to the courts? We'll find out. Others have hacked Greer's accounts. Other users created fake profiles of Greer and began impersonating him online. They created fake emails that purported to belong to him and began harassing places and people with those fake email accounts. You shouldn't do that. Legal advice, you shouldn't do those things. No matter if they're funny or not, you shouldn't do that. It's a never-ending stream of harassment. Greer has contacted the police and the district attorney of Salt Lake, and they never do anything. I mean, you will never find me disagreeing, you Russell, that in these types of matters, police don't do enough. As stated in the complaint, from October 2017 to June 2018, Greer has been fired from 5 jobs due to the trolls harassing Greer's employment. How do they keep finding out where you work? Greer tried publishing a book on his actions to try fighting the slander, but the trolls purposefully gave it bad reviews. Reminder, if you're new to the stream, Wednesday, live, Sriracha and I will be reading the first chapter of Russell Greer's book live and offering commentary to bring it firmly in the purview of fair use. Okay, because of the bad reviews, Greer can't market the book. It's the bad reviews, y'all. It's the bad reviews, y'all. Greer has been robbed of his ability to have the truth told, which is one reason why this current lawsuit was filed. Trolls have in groups published defamation onto review websites, such as a site called My Life. 115 random reviews painted Greer as a horrible person. One random review said, I wouldn't be Russell's friend. Ouch. Ouch. Another said, don't hire Russell Greer. Another review, Russell is delusional and mentally ill. These are all opinion statements and not defamatory, Russell. These reviews were all left around the same date of 11/20/2017, which shows that it was a coordinated group effort and not sporadic harassment. That's not how it works. It's not how it works. They have published Greer's number onto phone number review websites and leave bad reviews on his number. Simply blocking and requesting to delete negative reviews and trolls doesn't work because he blocks 1 and 12 new trolls come at him. That's a very specific number. Greer, professional advice. If you have a number that is less than 2 words long, you write the number. 12 would be a word that you write out. Just advice on what judges like to see. No high-quality jobs want to hire Greer because of the false reputation he has been given. He has applied to over 1,000 jobs in a year. This man is busy, and only 4 have interviewed him. 4 should be written out, and if you do that on your resume, you will have the same results. You should write out 4 on your resume. Greer has been evicted and essentially homeless because of the slander. Guys, he got evicted for this or because he couldn't afford the rent? They're 2 different things there. Greer has been unemployed and has had to collect unemployment checks just to eat. That's what unemployment is for, Greer. That's what it's for. Reputational damages are recoverable in a negligence lawsuit. Let's see the citation and see how parallel it is. Defendant, anesthetic company, negligently repaired machines. Plaintiff accidentally killed a patient with the machine. Plaintiff was able to recover for reputational damages. What citation are you picking? Guys, trolls online making fun of me is the same as me relying on a negligent repair and killing someone. The reputational damage of me sending nudes to someone I thought was Katy Perry is comparable to the death of a human. Oh my gosh. Physical injury. Plaintiff suffers from depression and anxiety. These are not physical. Psychological injuries, Russell. He has suffered with both since his teenage years. Note what he just did. Note what Russell Greer just did. He undermined his claim. The proximate cause of depression and anxiety cannot be related to his Taylor Swift fiasco because they predate Taylor Swift's career. Discovering trolls harassing him and discovering that Swift thought of Greer's efforts as troubling has caused plaintiffs to attempt to kill himself. Please don't kill yourself. Ignore my prior joke. It was literally a joke and very tasteless, and I apologize. Please don't kill yourself. Russell, I will be your friend, your literal friend, rather than you killing yourself. Let's talk. Let's talk. I think you're crazy and ridiculous. Absolutely. But I have crazy and ridiculous friends who I love very much. And I would love to be your crazy, ridiculous friend. Also, Greer's depression and anxiety from this incident frequently causes Greer's head to tighten. How does your head tighten? Oh, okay. Causes his head to tighten. I mean, I know it can. I don't know if he means what he says it means. Okay, to which he has to take medicine for. Do you get a headache? Or do the muscles in your head physically tighten up and cause you pain? I mean, I guess. Okay. Greer continues to lose employment over this. He can't go to a doctor and get his head examined to make sure he doesn't have anything else going on. Why not? Why not? Certainly, the great state of Utah has a public health program that will take in an unemployed man like that. If you're not making enough money, you're not making enough money. Obama fixed this for you, Greer. Also, one night as he was walking home, he had a truck toss a firecracker at him. Oh, which caused burns to his legs. Ow. Oh, that's mean. That's mean. I don't endorse that. I disavow. And I literally disavow because I have nothing to do with that and don't take any responsibility for it. Disavow the firecracker to the legs. Greer has been a target of harassment. On another time, Greer received a package that had powder in it. He became ill from the package. It was later determined to be non-lethal, but it made plaintiff lightheaded. Well, what was it? It was determined non-lethal, but what was it? Was it just like sugar? His former roommate, Paul Lopez, witnessed the ordeal, but didn't want to write an affidavit for fear of trolls coming after him too. Good job doxing him, since he didn't want that. Alley Cat, he needs to get his head examined. He does. He literally needs help. He's got issues here. And I mean, I'm an unqualified opinion, but I think any reasonable, based on what they've said alone about Trump's mental status, if they looked at any of this, they would say that Greer needs to immediately seek professional help. It was a bag. So Ascending Fire says it was a bag of dirt. Literally, someone sent him a bag of dirt with a card saying, "You're a dirt bag," and he tried to claim it was an anthrax attack. They should have sent him a CD from Anthrax so he could listen to some sweet tunes in the midst of his attack. Fear of violent assault. Greer's had several incidents stemming from this ordeal, which have made him fear for his life. You don't need a comma. Several times he has been in the grocery store and has overheard people say, "That's the guy who sued Taylor Swift." "That's the guy. Yeah, that's the one." And he is afraid they're going to attack him. Another incident, a woman actually came up to him. She actually did, and berated him over the lawsuit. How dare someone confront your ideas in public, Russell? Greer has received strange packages in the mail, as noted above. One package called Greer a narcissist. How dare they? No! Another time, a group of strangers shouted harassment at Greer as he walked on a sidewalk. Another time, a lady shouted at him, "I should sue you for being ugly." That's mean. Oh. With Greer's address on the troll sites, he is afraid he's going to be killed. Don't kill Russell Greer. Don't kill him. Don't hurt him. It's mean. This is a reasonable fear. I don't know if it's reasonable. Based on the 2017 New Mexico high school shooter who is a member of Kiwi Farms. No! Are you harboring high school shooters? Are you grooming them on Kiwi Farms? No. Answer for your crimes against humanity. Before the shooter went on his rampage, he has known when he was going to start shooting people. No! What are you doing? Greer is afraid for his family's sake. No, I can't believe you're coordinating school shootings now. No, I'm sending you to the NRA. We're going to get to the bottom of this. You're causing school shootings now. This is not cool, fam. Greer is afraid for his family's safety. Russell, no one should have to fear for their family's safety, guys. I think we need to let Greer know that his family is safe, that he is safe. I don't know how you do this. I'm not suggesting people contact Russell Greer ever. You will never find me suggesting that anyone contact anyone that I talk about online unless I specifically say, like maybe this person asked for contact, so please contact them. But outside of that, do not contact Russell Greer. But I would really hope that Russell Greer never be afraid for his or his family's safety. I think, Russell, if you're watching this and if you're watching the chat, no one wants you dead, buddy. Everybody wants you alive. You are far funnier alive than you would ever be dead. You being dead would be sad. No one wants sad things. No one wants to hurt your family. And if you do want to hurt Russell or his family, get your head examined. This is the internet. Laugh, eat, drink, and be merry. Whenever Greer eats in public places, he sits facing windows and exits for fear that he will be attacked from behind. Greer, I do this too, but that's just me. That has nothing to do with any fear. That's just manliness. Good job being manly in one aspect at least. When Greer sleeps, he places a heavy object in front of his bedroom door so that it can't be opened because he fears he will be killed in his sleep. Might I suggest a barbed wire wrapped baseball bat under your pillow for extra security, Greer? You're not doing enough. The Sixth Circuit allows for one to recover for fear of harm happening as a distinct claim from emotional injuries. Okay, let's talk about this citation. I haven't read it yet. I haven't read the citation yet. I'm guessing it doesn't have anything to do with this case. Class action. Well, it's already different. It's already vastly different than his case. For fear of contracting liver and kidney disease and cancer due to defendant corporation's dumping of hazardous chemicals in water supply. Russell, what does that have to do with trolls? Please come on my stream. We'll go through Westlaw together. I'll show you how to find proper citations that are applicable and relatable to the instant case, buddy. This is so far outside of what you're arguing that it's ridiculous. Okay. Loss of family relationship. No, this is going to be sad. Greer has a twin sister that he was separated at birth from. That's 27 years ago. I don't know if Taylor can be blamed for this. Just barely 5 years ago, he made contact with his birth family. He was barely building a relationship with them when the trolls went to the liberty of digging through everything in his personal life and began harassing his sister with fake email accounts. His sister thought it was Greer who was harassing her. Let me put out a public message. Sister of Greer. It was not Russell. It was mean people, and you should definitely rekindle family relationships because they're important even when your family's a weirdo. Be friends with your family. Family's the only person you have at the end of the day. Sister thought it was Greer who was harassing her when it wasn't. Now his birth family wants nothing to do with him. Birth family! It wasn't Russell. His birth family is the key to knowing about his future. I think it's more the key to knowing about your past. Such as if he will live long in age. If his family has any history of diseases, that's kind of important. There is only blood relatives and it has been forever ruined because of this entire ordeal. It's like you made bad decisions. Wait a minute. Greer is lying again. He was threatening to sue his sister because she wouldn't respond to his emails. Greer, I just stuck up for you. You owed me. You represented that people who stuck up for you would be listed in legal documents as people who tried to defend you on Kiwi Farms. You represented to me that people who stuck up for you would be acknowledged publicly, and you haven't acknowledged me, Greer. Lawsuit's coming, buddy. Lawsuit is coming. Emotional damages. Greer reiterates previously mentioned damages to fit his claim. Fit in this claim, Greer suffered fear for his life. He has suffered loss of relationship. I don't know if that has anything to do with his claim, my friend. He has a ruined reputation. Would you see he's got a bad reputation? Bad reputation. Right? Ooh, and I heard about you. He has damages stemming from knowing that Taylor Swift continues to interact with random fans while she shafted him after relying on her representations. Those interactions are essentially pouring salt into open wounds. Greer can't sleep at night due to his anxiety. Greer is constantly worried about losing further employment. Those are recoverable damages. Not so sure about that. Calculation of damages. Guys, I think we're almost to the end of Greer's complaint. I think we're almost there. Plaintiff estimates his general compensatory damages to be around... Let me point out that it's around this highly specific number. General compensatory damages to be around $22,069,000. You're missing a digit, Greer. $950. Plaintiff comes to his conclusion by estimating that he will live for another 50 years. I don't know if I should be charitable and say that it's 2,269,950 or 22,069,950. I don't know. I don't know what it is. His total lawsuit's for $100 million, so I have to think it's 22 million. He'll live for another 50 years as a paralegal graduate with an associate's degree and legal work experience. The National Association of Legal Assistants and Paralegals estimates that those who hold an associate's degree in paralegal studies earn an average salary of $53,399 per year. From What Can My Salary Be with a Paralegal Associate's Degree at Cron.com. If Greer being fired or unable to find a job due to Swift failing to warn is going to be a consistent pattern for 50 years. Greer is only still going because you keep going. Greer is entitled for lost future wages and would multiply 50 by 53,399 because he will work until the day he dies. He will work for 50 years and not retire after 30 years. The total would be 2,669,950. I gotta check his math. Okay. 5,399 times 50. Okay, that's right. 2,669,950. All right. Okay, Russell. As for reputational damages, but you overlook what comes next. As for reputational damages, several judgments have found those with reputational damages to be upwards of $20 million. How much is a damaged reputation worth? Medical Economics 2003. Medical Economics. The damaged reputation of a doctor. Russell. Not a paralegal. What are you doing? Greer asked for $20 million for ruined reputation and mental anguish and fear of violent assault and loss of family connection. Altogether, Greer seeks compensatory damages of $22,069,950,000. Now I'm going to be charitable and add in the 6. He means $22,669,950. Also, Greer doesn't sue the people and organizations involved in the chain of events for damages because Joshua Moon is unemployed, and so suing him would essentially be as effective as not suing him. Screw you, Joshua Moon. Further, federal law protects Moon as a site owner. Oh, there's just that federal bar to liability that you have to deal with. Although he has done plenty of harassment himself, such as publishing requests on his site of Greer wanting stuff removed. I'm not suing him because I can't win because he's unemployed. Oh, and also a federal bar to recovery. Exhibit A1. A1 steak sauce. Punitive damages will not be sought. In federal diversity cases. The legal standard is that the laws of the forum state are to be followed. The forum state in this case is Tennessee. Tennessee holds that punitive damages can only be found by a jury if it is determined a defendant acted recklessly. Yet you can't get punitive damages in a default judgment. That is correct, Russell. Greer initially stated his complaint that he wanted punitive damages to bring the amount to $100 million. He wrote that before he was aware of the statute that had been cited. Greer, why didn't you do your research? You just admitted to not thoroughly researching your claim. Therefore, Greer will not seek punitive damages as he can't prove recklessness on behalf of Swift. Greer can only prove negligence, which he has done. No. Entry of the proposed default judgment is in the public interest. Here comes the argument. The circuit has held that in certain civil actions, the public interest should be weighed. The relief Greer seeks is in the public interest. Although the damages he claims are in a private action, the defendant is a public figure. The action speaks for itself that Swift nor Russell speaks for itself that Swift nor any of her representatives chose to respond to this lawsuit, that none of them came forward to explain why Swift, an internationally famous celebrity, shouldn't have to use disclaimers with their publicity stunts, only because none of them have to do that. Because there's no required speech provision that has created that duty for them. When public policy and precedent says otherwise, no, not a single ounce of precedent or public policy says otherwise. They say literally the opposite. None of them have shown any sympathy towards Greer and the damages that he has claimed. The public does have an interest in this. A few months before commencing this action, a person messaged Greer and told him that she felt empathy for Greer's plight. Oh, goodness. Oh, goodness. She told him that her cousin did something similar as Greer. Her cousin was in a car accident and wanted to meet a certain celebrity. This person's cousin went to great efforts to have said celebrity see their efforts. Trolls saw the cousin and put it on websites mocking the cousin. For a while, the family was afraid that he would kill himself because the taunting was too much. It's apparent others have suffered similar harms doing similar efforts. In a world that idolizes celebrities, such disclaimers should be used to avert hidden dangers. Wow. It matters similar to the one at hand. In matters similar to the one at hand, courts have concluded that courts' authority to exercise full equitable powers is especially appropriate in cases like the one at bar. Equitable powers involve a contractual relationship. A judgment against Swift would be sweeping. She's considered one of the top artists currently. If she were found to be liable and in default, the ramifications would be swift in and of itself, which is why a court would be remiss to find her liable in default. Absolutely. Other celebrities would change how they do stunts. How all persons fictitious disclaimer came... wait. That's the citation I'm not even interested in. It's not a legal citation at all. Plaintiff would be prejudiced if a default judgment were not entered because without a final judgment, there would be nothing preventing future harm that could befall others who rely on Swift's actions. In addition, without a judgment for monetary relief, plaintiff would be unable to confidently move on with his life based on how ruined and fractured it currently is. A judgment would save plaintiff the cost of litigation. As it's apparent, Swift and her attorney do not care about the case. Finally, the failure to award default judgment here would create a perverse incentive for future defendants in similar actions by rewarding defendant failure to answer or defend this action. These considerations weigh heavily in favor of entering the default judgment here. Conclusions. For these reasons, plaintiff respectfully requests that the court enters the proposed default judgment against defendant Swift. Respectfully submitted. You didn't sign it, Russell. You didn't sign it. I guess that /R Greer /. Oh, wait, there's a signature. Sorry. I didn't read down. Oh, because he has the signature block up here. I figured he'd sign it there. All right. Here's all the exhibits. Guys, I'm not going to go through the exhibits. This would take all night. It would take all night. All night to go through those. Let's do one better. Let's, you'll have to bear with me. I actually didn't prepare this. Very unprepared. Let's get Taylor Swift's response and go through that really quick. It won't take long. Won't take long. We have all night. Just a second. Maybe we should start going through. Them. Give me a second. I'm getting, I forgot to download the Taylor Swift's response. So I'm going to do that. Just do one exhibit. I'll do a couple exhibits. The Pacer website is going very slow right now. Come on. All right, let's see Exhibit A1. Exhibit A, request to waive service. Mr. Briggs, please find attached my document to waive service of summons to save me cost expense. Since you are her attorney and are thus a representative that can get this to her, you accepting service will suffice. Please sign the waiver and scan back to me. Thank you, Russell Greer. Yeah, I'm sure he's really interested in doing that on behalf of his client. Why is this going so slow? All right, let me try reopening Pacer over here. Sorry, guys. I meant to have this downloaded beforehand, but I ran out of time. And the autistic Kiwi Farms will definitely figure out my password and username from the keystrokes that they just heard. All right. I am going to read the exhibits. Especially the Katy Perry one. Okay, save. Let me get this pulled up. I apologize for everybody watching at home. You're in the midst of a live stream. It's an ambush live stream, and I apologize if you're watching after the fact. Okay. Let's see. All right. Here is T-Swizzle's response. But let's go through some exhibits. I'll hang out with you a little while longer. My friendly chat. Okay. B. The old Taylor can't come to the phone right now. Boom. That's a representation. That's Russell, what? The fans are the best part of this tour. Look at these fans. Of course. That's in New Romantics. One Chance exclusive first look with Taylor Swift. Regal Movies. Okay. Like, this is literally an announcement of an endorsement. Exhibit A1 is the one where he just screen caps Null's Kiwi Farms profile and Vordak's wiki article on me. We'll find it. Exhibit E. Taylor Swift surprises fan with a special performance of Blank Space at his wedding and gave him a handmade gift. Look at this guy! Decorated soldier, apparently. Exhibit F. All of us are praying for you. Taylor Swift donates $50,000 to her backup dancer's baby nephew who is battling cancer. Well, that seems nice. Again, none of this creates a liability. So now every person on Earth who's a fan of Taylor Swift, their baby nephew has cancer, she's now required to donate $50,000. That's what you're asking, Greer. Exhibit G. Taylor Swift, let's rock out together. Please visit my Kickstarter and help me kickstart my dream. Hashtag swiftly wooing Taylor Swift. Good job, buddy. Here's the Kickstarter for Russell. Wait, is that Russell? I can't tell. Is this Russell? I get you Taylor Swift and other feel-good pop music. Kickstarter.com. Oh. Unsuccessful. These projects may not have been fully funded this time. You can always try and relaunch. That's right. Oh, I wonder how it did. I get you. This is his IP. Just put it out there. Russ Greer is composition. That's it? That's your whole song? Carly Doe, MBA CLM, Executive Director of Trask Brit. Charlie Doe. Okay. Look at this exhibit. Here we go. Is there any resemblance between him and Taylor Swift? Or if there's any resemblance between him and Taylor Swift, is that they both play the victim all the time. This girl's crime, unfriend him on Facebook. And then Harley Swift sent him, no one cares, ha ha ha, you are such a flop, man. If you think T-Swift ruined your life, boo, you die, BTCH, ha 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 ha. They sent him an Encyclopedia Dramatica article. And you're a fat sack of poop. Rude. Warning, if you don't date Russell Greer, he will sue you. Look at the reputation damage that 48 views got him. Christopher Lockery, how rude of you. Next exhibit. Jay Shotties to Russell, CC Robert. Dear Mr. Greer, after you had sent some additional correspondence about your music, I called this morning to speak to you. I got your voicemail and left a message explaining some of the legal reasons why neither we nor Taylor can receive, open, or forward any unsolicited material. I truly do wish you the best in your efforts. I hope you and your songs find the right audience. Sincerely, Jay. That is the nicest possible email from Taylor Swift's agent that he could possibly get. That is the nicest email he could get. Oh my goodness. That he even got a response is literally remarkable. They should have said, stay away, creep. All right. Here's another email from Email My 2J Shotties. So here is Russell. Russell responding. Misunderstanding in yesterday's email. I'm trying to forward a fan-made song to Taylor that cost me $400 to produce. So? Please forward to her. I'm not trying to pitch a song. If the song is not forwarded, it will have been a waste of time and money. Yes. Yes, it will have been that, and it is that. I only want her to smile. I don't know how else to give to her, so that's why I contact you too. Jay Shotties, dear sir, Taylor writes all her own music, and none of us can or will accept unsolicited works. Not works sent for production, works of any kind. This will not be forwarded or opened. I wish you well in your endeavors. Next. His admiration of Ms. Swift to an unnecessarily invasive and troubling level. For her and increasingly for her immediate family and senior management team. That's what he says. This must be the response in the Utah lawsuit. Daily Mail. Utah man sues Taylor Swift after her agent stonewall his efforts to make music with her. There's Tay-Tay. There's Russell in a charitable picture of him. They could have used something much worse. It is Daily Mail. And Daily Mail is basically a tabloid, which is happy to use unflattering pictures of people. Russell Greer from Salt Lake City blames Swift's agents for not forwarding his music to her. He believes he is entitled to the singer's attention. Entitled is highlighted. Mr. Greer was allegedly told multiple times the Shake It Off songstress had no unsolicited music policy. Of course she does. Here we go. So this is Exhibit O. MatthewHopkinsNews.com. Kiwi Farms gossip and exploitation of the mentally handicapped for amusement purposes. Kiwi Farms is run by pedophile sadist Joshua Connor Moon and exists to harass the disabled. Click for full size. Joshua Moon, you need to answer for your pedophilia sadistic crimes. Here's some text Russell got. Russell, you piece of garbage. I'm censoring because I'm a good boy. All your information, including phone, home address, work address, etc., will be published to the trolls unless you unblock me. What? Who is this? It is Zig. It is Zig. Sorensen was very helpful in providing me everything I need to know. Why you deactivate your Facebook, Russell. There you go. Notice, there's no allegation that Zig or anyone else is affiliated with Taylor Swift in any way, But we have learned from this lawsuit that Taylor Swift is responsible for the actions of everybody on the earth. Mobius Lipschitz is... Okay, that's rude. Greer poop lips rusty, and Greer is... Greer is photoshopped into a terrific meme. Do you follow Taylor Swift? Yes. On Instagram? No. I personally love that meme. It's one of the funniest ones out there, in my opinion. Russell Poop Lips Greer. That's a little mean. It's mean and insensitive. Exhibit Q, why I sued Taylor Swift and how I became falsely known as frivolous, litigious, and crazy based on the true event. And again, Wednesday, Chapter 1 will be reviewed live with commentary and legal criticisms. Stay tuned for that. 670 people are searching for you. That's ominous. On my life. Your reputation score is 2.675. I don't know what that means. My jobs. Okay. Applied 1,117 jobs. This doesn't actually mean anything because we have no idea if those jobs are in relevant fields or anything to that. You can get a lot. You can get a lot of applications for jobs that you will never get interviewed for. Notice to terminate tenancy. Okay, here comes the notice. This is what the landlord sent to Russell. To tenant and all others in possession of the premises located at 3306 East Del Verde Avenue, Salt Lake City, Utah, 84109. Russell does not live there anymore. He has terminated his tenancy, so this is not a dox. Please take notice that your month-to-month tenancy under which you hold the possession of the herein described premises is hereby terminated as of the date 30 days after service of this notice upon you. It's important to note, guys, that a month-to-month tenancy can be terminated for any reason so long as you provide sufficient notice under the law, which is typically, I'm not positive with Utah, but at least in Minnesota and several other jurisdictions, typically 30 days notice or one billing cycle. Okay? Oh my goodness. 30 days after service of this notice upon you, you are hereby required to quit and surrender possession thereof to Jessica Hirschberg on or before the date of November 3rd, 2017. Rent will be prorated for November if not vacant by October 31st. Failure to do so will result in forfeiture of the lease and or rental agreement and will institute an unlawful detainer lawsuit against you to recover rent damages and possession of said premises. If you're in a month-to-month lease, you have no legal standing to maintain that lease unless you can show that it was unlawful, discriminatory act, like maybe they don't lease to black people or something like that, or terminated all leases to Asians, for example. That would be a violation probably of some anti-discrimination or civil rights laws, but just being terminated as an individual on its own, not going to happen. Not going to be able to fight that one. Current claim for Russell Greer. Unemployment. He gets $264 a week. The maximum benefit is $6,864. Good job, Russell, I guess. I don't know. Someone sent him a bag. Says you're a dirtbag. Seems mean. Meanness is not illegal. It's important. Matthew Hopkins news. Atchison and Moon. So this is about school shooter Joshua Moon. School shooter sympathizer. Atchison and Moon were acquainted, and chillingly 3 days before going on his rampage, Atchison posted on Kiwi Farms under his username FU, asking how long before Moon would do so. So how long until you conduct a mass shooting? Kiwi Farms member William Atchison under his username FU as his friend Joshua Connor Moon null. How long before he conducts a mass shooting? I'm not sure legally how that implicates Joshua Moon in a mass shooting conducted by someone else. I don't know how that works, but that's an interesting theory. Okay. William Atchison Suicide after murdering 2 students. Was a user of Kiwi Farms who garnered infamy and mockery in the community for his involvement in the Aztec High School shooting. And he's got a very hateful image of, what's his face? Why can't I think of it? What's his stupid name? Death to Smoochie. Obviously, this is from American History X. My name is blanking. Whatever. You guys know who that is. I keep going back to Ethan Hawke because of the stupid Family Guy thing. But it's not. It's what's his name? I'm not going to think of it. Someone else can say. Okay, here is Exhibit X. This must be the Katy Perry. Ed Norton, thank you. Thank you. Edward Norton is the guy. I've been called a cut rate Ed Norton before. I think that's giving me too much credit. I just wanted to say, I saw your story and I found it super upsetting. My cousin back home was paralyzed. Oh, this isn't Katy Perry. This is something else. Cousin back home was paralyzed in a car accident when he was young, and it's a similar story to yours. Put a ton of effort in creating a song plus video, and the video centered on his struggle as a disabled person. Sent the song/video out to a few celebrities, and some people on Reddit, cringe subreddit, found it. They harassed him in droves, and he ended up deleting it all, and we were scared he was going to kill himself for a while. This is a few years back, but I just want to let you know that you'll be okay, and lots of people go through the same thing. This isn't a person telling you to keep going. This is a person empathizing with the emotional aspect of your struggle and saying, don't kill yourself, Russell. Don't kill yourself, Russell. He even found a support group of people. Maybe you should pay attention to that part you didn't show the rest of. Find a support group, Russell. Oh, wow. Exhibit Y. Russell Greer. Is that his intimate? Wait, is he in heels? What is happening in this picture? What is happening in this picture? Russell's got some nicely shaved legs. If that's Russell. Okay. So this is not Russell Greer. I'm being told. Guys, I'm not up on this goss, so help me out. This is allegedly a person claiming to be Katy Perry. Right? Sent to him by someone claiming they were Katy Perry / someone representing her. Thank you for clarifying this. So that's not Russell's nicely shaved legs, although this does not look to me at all like Katy Perry or in any way appealing to me. Those look like manly legs that are shaved. Very muscular. I'm not sure about that. Oh. Okay. I was hoping he would post his own intimates. 5 messages don't have the godly Loki looks. What may seem as me being stubborn or level-headed, which I'm totally not. I'm actually quite content and happy right now, and grateful you took the time out of your busy day to call me, is actually me just wanting to be treated equally. I'm a paralegal. Not one legal, I'm a paralegals. I think through problems and I analyze. Okay. I started on this quest to impress her and write music for her after seeing her accept prom dates, wedding invites, going to charities, visiting kids in the hospitals. While all that was sweet of Taylor to do, none of it benefited her in return. And then I saw her do collaborations with other artists, so thus a confusing rule is created. No! Collaborating with Ed Sheeran is way different than going to prom with a kid. Her contract won't allow her to accept material to be pitched to her, but the contract allows her to work with others. Yes! Yes! Her contract... Never mind. Guys, if you can't figure that out, I don't know what to say. Joshua Moon. Look at this. Pedophile. There you are. And there's your picture, further confirming the pedophile. Oh my gosh. Oh my goodness. Oh, he doxed himself. Doxed himself right there. Good job, Russell. Okay, guys. Let's quickly, very quickly, go through Taylor Swift's response, which I thought I had pulled up, but apparently I don't. Here we go. This is Taylor Swift's response. That was the entire complaint. All the exhibits. Oh, that's his former roommate Paul Lopez's address. Russell has all sorts of good. All right, so this is a very long response. It is 3 pages. As you can see, it is 1 page of substance. Mind you, Russell submitted 91 pages, 20 pages of legal argument, and then 70 pages of exhibits. Taylor Swift's lawyer responded with 3 pages. Here we go. Defendant hereby opposes the motion for entry of final default judgment filed by plaintiff and states as follows. Plaintiff's motion must be denied because the defendant has not been served with a summons in the complaint in this action as required by Federal Rule of Civil Procedure 4. Citing Blake v. Benston. Prerequisite to the entry of a default judgment against the defendant, however, is a service of process on the defendant pursuant to Rule 4 of the Federal Rules of Civil Procedure. No service of process was made on defendant in the instant case, thus defendant cannot be in default. Number 2, the entity allegedly served, Venable LLP, is not a party to this action and is not authorized to accept service on behalf of the defendant. Russell Greer, sorry buddy, you lose. This motion is being filed for the limited purpose of ensuring that the court does not enter a default judgment against defendant for the reasons stated above. Defendant is not entering an appearance in this action and reserves all rights and defenses in the event service is ever obtained. Respectfully submitted, Natalia L. Rose, Rose IP Law PLLC, which, if Russell Greer had merely Googled who is the attorney for Taylor Swift, would have found out that Natalia L. Rose is the most recent lawyer representing her, at least as far as I could tell. So, this is a limited entry, which means that the sole purpose of this is to oppose the default action. It is not an admission of service. It does not allow the court to move forward. It does not allow the court to provide jurisdiction. Russell Greer has potentially, or may potentially, pass the window for filing. I believe he has 90 days and he has not passed that yet. But he may have. He may have. If he passes that 90-day window, his suit will be dismissed, probably without prejudice, and he would have to refile, repay the fee, re-lose the informa pauperis motion that he made, and still have to pay the fee, and then have to still sue them. Now he knows what law firm is representing her, although that does not necessarily mean that Rose IP Law is authorized to accept service. They do not authorize, or Taylor Swift does not authorize Rose IP to accept service just by her filing a motion on Taylor Swift's behalf opposing a default judgment. Taylor Swift has to be properly served by Russell Greer, and if she is not properly served, he loses, period. And she doesn't have to help him. She doesn't have to make her attorneys available or anything like that. So as of right now, my legal opinion is that Russell Greer is about to get BTFO'd by a federal judge and may have several other problems that spring up as a result of this. But certainly Taylor Swift will not lose on default judgment. If she does, I don't know, I'll eat like a shoe or something. But she won't, because he just has not followed proper procedure and his case will lose. Anyway, guys, thank you so much for watching the Russell Greer video here. I know it was long. Blame Russell Greer for that. And I'll catch you later. Have a good night. All right, guys. That is that is the end of the third stream I had prepared. That is the end of the third stream I have prepared. It is not done yet. It is not done yet. Oh, I am really, really tired. I'm really, really tired. But I have talked about doing a live composition of a cease and desist letter to Maddox. So if you want to stick around for that, stick around for that. Let's make that happen. Ben Honeycutt, don't fight me, buddy. We're going to put this into action right now. Let us get the let me get this document prepped. No, you don't need to be a lawyer to send a cease and desist letter. That's not a requirement of any sort or any kind. You should probably have a lawyer help you draft a cease and desist letter. But you don't need to be a lawyer to send one. Anybody can tell people to stop doing something. Cease and desist letters don't have like a force of law behind them. That might be a confusion that people have. But there's nothing about a cease and desist letter that compels people to obey them. It's just you telling them, look, you do not, you can't do this anymore because of this legal theory. So, all right. Okay, I'm almost ready. Let me just prep this. Sorry, guys, I gotta. Oops. Here we go. Let us go ahead. I just have to prep this, and it's got some information on there that I can't put out in public just yet. So let me just get it ready, and then I'll get it up on screen. I'll get it up and say, yeah, cease and desist is a formal way to say stop it, and you can provide context as to why. Okay, let me see if I can get this pulled up here. What is that? So it says it's capturing the, whoops. It says it's capturing the window, but it's not actually capturing the window. I think I went through this last time. Very annoying. Okay, let me, we'll do it this way. Let's do the, whoa, not what I wanted. Hold on. Boomerville. Boomerville is happening. Okay. What is even happening here? What is going on? Okay. Here we go. Here we go. That's not the right one. Go away. Adobe here. This, guys, this is, you cannot get a better. Okay, here we might be going. No, not Adobe. Okay. Almost there. Seriously, this is embarrassing. Hold on. I gotta shrink me a little bit. Okay, we're making it happen. All right. Okay, now I need to increase the zoom on this, and then we're about ready to go. Zoom. Okay. Okay. This is the best I can do on short notice. On short notice. All right. All right. All right. So let me see. So Maddox was on the Doug Tenapal show. Should I show that again? Do you guys want to see that video one more time to have a fresh view of what we're referencing in this cease and desist letter? Let me know if you want to see that video real quick while I get started drafting. Yes. Okay. Okay. I will post the relevant clip here in just a moment. Here we go. Media source. It's only like a minute and a half. Here we go.
Chats even work. Here's Rekieta Law for $5. Maddox, buddy, will you come on my show and talk about your experience with Landau? The answer why he thought he could bring ethics charges against me. So this is a person who has
this guy is a stalker. It's insane. I don't know this guy. He follows me around everywhere. By the way, here's what I do know about this guy. He's a blackface lawyer. He paints himself in blackface. So yeah, I don't want to talk to you, dipshit. I don't want anything to do with you. Like, fuck off. He's such a hypocrite and a lie. This guy, by the way, Doug. Like he's like, you know, he's told some people's like, leave Maddox alone, don't bother him, and here he is bothering me. This guy's a stalker, dude. Fuck off. I don't know what your beef is with whatever, but it has nothing to do with me. Fuck right off.
Wait, so Maddox, is that a no?
That's a maybe. That's a hard maybe.
Cheers.
Well, there you go. Now, some of you who have not followed the saga that is me, may not know the origin of one of Maddox's claims. So I'm going to candidly talk about it because I will candidly talk about my life. I'm a very open person in general. So let me tell you about why Maddox has claimed that I'm a blackface lawyer. Around, I think it was 2006, okay? I graduated from my undergraduate college in 2005, all right? With a literature and creative writing degree that has done me wonders. In 2006, I was married. I had friends. This sounds like the beginning of a sad story. That's still true. I'm still married and have friends. At least I tell myself I do. In 2006, I hosted a Halloween party in my home. In my home, okay? And my best friend at the time, and a very good friend to this day, although we just don't get to hang out enough, and I'm too old to have whatever is a best friend. But a person who I spent a couple years hanging out with every single day, and several hours pretty much every night. If you asked the staff at the local Perkins, they could attest to how much we were there. This is a person I hung out with every single day for several years, okay? I invited him to my Halloween party. He happens to be a comically large black man. He's about 6'8". For reference, I am 6'2", okay? He is about 260 pounds of muscle. I am about, right now, 180 pounds of some minor combination of muscle and mostly bones. I'm a thin-ish person, but he is a very large and strong person. I borrowed some of his clothes as a joke without him knowing why, and I bought a tube of black face paint. And I invited him to my house, and I dressed up as literally him, in the privacy of my home at a private party. He came over. It was a very funny joke. It was not a funny joke because I was dressed up as a black person. It was a funny joke because I was dressed up as someone who is physically, comically larger and funnier than I am in every way. I'm 180 pounds now. I was probably 165 pounds at the time of this. So we're talking about a person who is 100 pounds more muscle than I am, okay? And I dressed up as him as a joke for Halloween because I thought it would be funny. And it was very funny. He enjoyed it very much. The other guests enjoyed it very much. We all had a laugh. And then we went and watched Jackhammer Massacre, which I do not recommend. Terrible, terrible garbage movie, okay? But that was it. That was the joke. The next year, I dressed up as Britney Spears. I had a theme where I dressed up as individual people who I thought would find funny for Halloween parties that we hosted. That's that. That's the only time I've ever been in anything resembling or approaching blackface. It was also probably the worst case of blackface in the history of man. That was part of the joke as well, was that it was a terrible makeup job. I didn't shave my mustache. I just smeared the paint over the mustache. Anyway, so that's where Maddox got the idea that I'm a blackface lawyer. Mind you, I would not become a lawyer for another 8 years after that, I think. 8 or 9 years after that. And I have never once left a residence in anything even close to blackface. I find blackface moderately offensive because it makes fun of exaggerated things and it disenfranchised black actors. I get it. I get why blackface is offensive. What I was doing had nothing to do with a minstrel show or otherwise theater performance or even exaggerating characteristics. Literally me being my friend as a joke. So, and I would dress up like any of my friends as a joke if I thought it would be at all funny. So let me put that out there publicly. I've been open about this since anyone has ever asked. My story is the same every single time because it's the truth. And one day I will have that friend on this show and you guys are going to love him. You're going to love him because he's interesting and brilliant. Interesting and brilliant guy, and we're going to have a great conversation someday. But until then, you'll just have to take my word for it. So anyway, that is where the blackface thing came from. Other than that, no, I don't dress up in any sort of costumes to offend other people. I dress up in costumes that would be funny, but I haven't done that in years because we moved away from most of our friends and don't really host Halloween parties anymore. So whatever. That said, I have never practiced law while in blackface. I have never left my house while in blackface. I've never engaged in stalking of any kind. And so those statements that Maddox made are false statements of fact about me. And I'm about to write a cease and desist letter to tell him that that is unacceptable. So here we go. Here we go. Would you dress up as a long-haired, small-faced Mexican? Absolutely. Absolutely. And Where Tiger Ray says, a historical note about minstrel shows, there were actual black people who did shows pretending to be white people, pretending to be black people, and that's too meta for me. That's far too meta. But if you stalk someone while in blackface, I don't think so. But I might have been drinking at that Halloween party. But actually, I think that Halloween party was before I drank. So I don't know if that's a true thing. We'll see. I guess we'll see. Someone will find it if I have. All right. So let's do this. So I have this letter prepared. It is dated September 17th, 2018, which is today's date in my time zone. It is titled Maddox. It is titled Maddox. So Maddox. What day? So he was on Doug Tenopol's show on September 15th. So the important thing is to lay out the factual basis, right? You want to lay out a factual basis. So on September 15th, 2018, you appeared on the YouTube show of Doug, whoops, not a comma, Tenopol. Maddox can't watch any movie with Robert Downey Jr. Okay, so you were on the YouTube, you appeared on the YouTube show of Doug Tenopol. Perfect. I'm not going to trademark YouTube's stupid thing. That's up to them. The YouTube show of Doug Tenopol. In this show, the audience was invited. I'm going to borrow Russell Greer's argument to provide super chats, monetized questions or comments in the live chat section, in which they could request or ask a question or make a comment to the host. I, Nicholas Rekieta, under my username, Rekieta Law, sent such a super chat requesting you to appear on my YouTube show to discuss your legal experiences with a particular lawyer, Kevin Landau. All right. My show is an educational / entertaining review of legal matters within the popular zeitgeist. Because I know that Maddox had to hate the word zeitgeist on The Biggest Problem whenever Dick used it. Oh, I should do a colon there. Okay. Okay. I have heavily covered your lawsuit as it overlaps with fans of my show who are interested in you, Dick Masterson, Asterios Kokinos, and other defendants named in the suit. Having you on my show would be relevant to our mutual fan bases, as well as the content I put out regularly. Shouldn't lawyer be in quotations for Landwe? All right, so here we go. In responding to my super chat, you made several false and salacious allegations that amount to defamation. Whoops. Under relevant state and federal statutes, as well as common law. Defamation. Whoops. Defamation is a false statement of fact to a third party, Doug and his audience. Let's see. Right, this next C and D is a sovereign citizen. Defamation is a false statement of fact made to a third party. That causes or can be reasonably expected to cause harm to the subject of the statement. In cases of public officials, we'll say public figures. The statements must be made with a knowing or reckless disregard, or knowing falsity or a reckless disregard for the truth. Specifically, you suggested I was first a stalker and second a blackface lawyer who goes around in blackface. Am I going to include an invite to the show? Oh, how do you know me so well, you minx? Of course I am. Of course I am. And I'm sorry that my keyboard probably sounds like the thundering of elephants. Okay. I am neither of these things. And the falsehood of those statements is known or should be known to you. Stalking. I have in no way stalked you. I have never met you in person. I have never sent an email. I have never called you. I have never sent you a direct message or otherwise directly contacted you over social media. The closest thing I have ever done is to enter your public Discord and politely invite you to appear on my show. Let's see. While following every rule in your Discord server. Oh, yeah. Suggested is too weak. Correct. Thank you. Thank you. You stated I was first a stalker and second a blackface lawyer. Thank you. Thank you. I was not replied to, and I made no further attempt at communication with you in a direct manner until the Doug Tenapel show. Stalking typically requires... Let's see. Let's look up the statute for stalking in Minnesota. Whoa, 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 whoa. I just realized my tabs are open. I don't think you can actually see them. Whoops. Clicked on the wrong thing. Here we go. Stalking. All right. So, in Minnesota, the definition of stalking is, as used in this section, stalking means to engage in conduct which the actor knows or has reason to know would cause the victim under the circumstances to feel frightened, threatened, oppressed, persecuted, or intimidated, and cause this reaction on part of the victim regardless of the relationship between the actor and the victim. There we go. Should Doug Tenapel show be in quotes? I don't think so. Typically requires knowledge of the actor that the action undertaken will result in some form of fear or apprehension in the victim of the action. I have contacted you 2 times with zero knowledge or even suspicion that it would cause you to cower in fear. Let's see. Both of my contacts have been in open public forums, respectfully written, and have not, let's see. I think we'll just put and respectfully written. All right. So, blackface lawyer. I have never practiced law in blackface or in any iteration, any conceivable iteration of blackface. Further, I have never gone around in blackface, nor have I ever appeared publicly in blackface or anything even resembling blackface. Let's see. Catch you later, Robert Davidson. This is just, and guys, I don't know that this is interesting or funny to you at all. This is just how these things go, right? Like, this is how you write a cease and desist. Yeah, that's about it. That's about it. So I'm just filming this as I write it because, one, it gives me incentive to actually write it and send it. This will be more fun. So is it possible to stalk someone online? Sure, absolutely. Absolutely. You can think about it this way. Let's say you go on Facebook and you send someone a message and you say, I'm following you. I'm watching everything you do, right? Let's say you do that. And then they say, please stop contacting me. Or they call the police on you or something. And the police tell them to stop contacting you. Whatever it is. And then they block you. Okay? And then you make another account and you do the same thing because you got a reaction out of them. That can certainly be stalking. You know that you're causing fear and apprehension in the person. Or you maybe should know that you're doing that. Or maybe their sister or mother or father says, hey, can you knock this off? Or their friends says, hey, this is putting him in a bad place, him or her in a bad place, and please just stop doing this. There's no reason for you to do this, and they're having real trouble with this. And then you persist. That's stalking, absolutely. It's once your actions traverse into the idea that you know you're causing someone fear or apprehension, and you keep doing it. That is stalking. If Maddox ever told me, don't contact me, I wouldn't contact him. Outside of something like this, where he has said, you can't tell someone not to contact you and then do a bunch of illegal things to that person and then say, don't contact me, and hope that that doesn't result in like a lawsuit or something like that. They're valid legal claims. I believe I have been personally wronged, right? This guy and his agents, by the way, his agent, I will call him his agent, has been carrying on this blackface falsity for a year, for over, or almost a year now, has been publicly saying that I go around in blackface, has been misconstruing an old picture, representing it as a current picture, has contacted the Minnesota Bar Association, has attempted to contact CNN, Huffington Post. There's a person who is associated with Maddox who has attempted to spread this lie about me for now 11 months. Okay? I have let it slide. But Maddox made a personal statement about me, definitive statements of facts about things that I do that are not true, in an attempt to discredit and damage my reputation. I'm sorry. That is unlawful. That is defamatory. And now Maddox will understand that he can't do those things. I'll be demanding an apology. So, that's how that goes. Hopefully that works out. Now, let me get back to this so that Zarther doesn't scream. Blackface or anything resembling blackface. In fact, since being admitted to practice law, or even being admitted to law school, I have never. Let's see. Well, no. Let's not put that in. You would know this with any. Sorry, not supposed to put all caps in a cease and desist, even when you're pissed off. You know this with any even rudimentary research, as I have openly discussed all allegations of said events. In fact, I have been responding to agents and actors who are acting on behalf of your company, Madcast Media, for 11 months. Whoops, not supposed to type that out. 11 months now. In each instance, I refute the accusations with the actual facts of the situation. You and your agents have actually been literally stalking and harassing me for 11 months. For 11 months. To make this false statement, or for you to perpetuate this false statement about me in such a public forum is beyond the pale. I demand that you immediately cease and desist this behavior, this unlawful behavior. I also demand a public apology. It can be written or oral. And may be delivered to my office address below, or may occur as an appearance on my YouTube show. I would prefer to discuss this as an adult or to discuss this as gentlemen, because while we disagree on several things, I still think you were misled. No. Not gonna go there. Not gonna go there. Oh, yeah, I can act. Okay, the retraction, yeah. Maybe. We'll see. Let me think about that. The problem with the retraction is he can't go on Doug Tenople's. I mean, I could demand him to go on Doug's show, but I can't demand that Doug do anything about it. Is there a legal definition / understanding of being one's agent? I'm a legal layman. Yes. An agent is someone who either is authorized to act on behalf of a principal, someone else, it can be a company, it can be a person, or they hold themselves out as being able to act on behalf of that person, and the general public would reasonably believe that holding out to be true. Okay, so that's the two-part test of agency, principal agency relationships. Someone from Madcast Media has been perpetuating this lie about me for 11 months. I believe that person who has since ceased his relationship with Madcast Media and similarly has ceased making the allegations. I believe that that person was acting on behalf of Madcast Media, and I have reason to believe so, especially confirmed by Maddox's statements about me on Doug Tenople's show, which strongly resembled the rhetoric being used by this other actor who is acting on behalf of Maddox. So that's how that works. Hopefully that helps you understand principal and agency. Yes, a specifically soft agent. Right. I would prefer to discuss this. I don't like gentlemen. I would prefer to discuss this publicly, as I believe that would provide the proper amount of remediation for any potential damage to my reputation. If you refuse, I will consider legal action, all legal avenues for recourse available to me. For your information, defamation occurs in the forum which would be most damaging. In this case, you may be required to appear for your defamatory statements in the state of Minnesota, where the highest amount of damages would occur based on your statements. I will further suggest that in the case of defamatory statements involving allegations of criminal activity, damages are presumed. Stalking is a serious crime that carries both legal and ethical implications for the accused. I will consider prosecuting this to the full extent of law, both criminally and civilly, as I have endured nearly a year of defamatory statements from you or your agents, specifically designed to damage my personal and professional reputation. This is the forever stream. Slothfather, yes, people do prosecute to the half extent of the law. They may only pursue one of the two claims that are out there, for example. Please consider my offer and contact me as soon as possible. If you do not respond within 14 days of me sending this letter, then I will All right. I think that about does it, guys. I think that about does it, guys. Let's see. I want to prosecute to the 1/4 extent of the law. When someone steals my stuff, I want to pay them to get it back. You know, like the government. So, yeah, I mean, this is sufficient. I think this might get my message across. I'm going to send this to Maddox. Oh, I should put to Maddox and counsel. What's his name? Joshua Libu. Jonathan. Let me see. What do we got here? Jason Libu. So, I'm going to send this to Maddox, and I'm also going to send it to Jason Libu. That way, Maddox can't claim that he didn't get the document. Jason Libu will probably not... This isn't service. This is just a cease and desist letter. So, Jason will probably not, have anything to do with the service, but he'll probably let Maddox know that he got this. And he may have to bill Maddox for the time that he took to respond or to forward the information on. And I'm sorry, Maddox, that I have to do that to you, but I have to make sure that you know that this letter came to you. Will Maddox understand what agent means in this context? I don't care. I don't care if he would. So, all right, guys. Well, I am going to... this is already saved. I will go print this on my letterhead tomorrow, and then everything will be done. I will mail it out, and that'll be that. So, what is... All right. I think we're about done with the stream. This has been a exceptionally long stream. But, we had 3 videos to cover. We had the extra goss in there, and that's just how things kind of went. So, I apologize. What is happening here? Oh, I need to move. Oh, here we go. No! Oh my. I've completely ruined my OBS setup. All right, guys. We did the 3 video recordings. Those will be posted as soon as I can get them done. That'll happen. And that's, I'll get those posted as soon as possible. Individually. Thank you so much for joining me on this long stream. Please remember, tomorrow's stream will not be 4 hours, I don't think. Gosh, I hope not. But I will be interviewing convicted pedophile who is the subject of the previous video I did. We've read his court documents. Let's hear the words from his own mouth. Let's hear about his experiences, about what his problems with the systems are. Please come check that out. Tomorrow at 11 p.m. Central Time. Same time I always have been streaming. Thank you so much, guys. I'm gonna just wrap this up because this is really, really long, and that's what she said. And I love you all. Talk to you soon. Peace.